We are, as you just heard, we are recording this. This will be the first time in years that this has been recorded. It will be available for watching on Uptown People's Law Center's website and perhaps also on the district court's websites. This seminar this morning is co-sponsored by both the Uptown People's Law Center as well as both the Northern and Southern Districts of Illinois. The reason that the district courts are co-sponsoring this is because we have a unique program here in Illinois in those two districts where prisoners can write from their cells on a piece of paper, file something in court, and ask to have a lawyer appointed. Obviously, it's not a guarantee. There's no right to have an appointed lawyer, but the Seventh Circuit has been fairly aggressive in reversing cases where prisoners clearly could not represent themselves adequately, and the Federal Rules of Civil Procedure allow for courts to appoint lawyers to represent prisoners, and in the Northern District and the Southern District, they do so quite regularly. Most other circuits throughout the United States don't have as organized a program as these districts do. Now, most of the lawyers that get appointed have significant backgrounds, not, however, in prisoner rights. They're usually experienced trial lawyers, know their way around the courtroom, know their way around the rules of civil procedure. But what we're doing is we're providing you with that sort of basic information that will allow you to move from A to B to C, doing a civil rights case on behalf of a prisoner. For those of you who have not ever done one, we're going to give you more information than you can possibly absorb during the sessions today. But our goal today is to get you to the point where instead of looking at this and saying, oh God, I have no idea how I'm going to do this case, you feel I can do this. It'll give you the basic cases, it'll give you the basic outline, and perhaps more importantly, the basic way the Illinois Department of Corrections is organized, so that you know the sorts of documents that might be out there, the sorts of ways you can seek to prove your case. As we move through, the question and answer box is open, so you can post your questions there, and we will try to get them either as we go along, or I tend to take breaks in order to catch up if there are any open questions that I've not answered as we go along. The first thing I think it's important to know is that when you get appointed to one of these cases, it's important to move quickly. All of us as lawyers are overcommitted. People say that sometimes we're procrastinators. I don't think that's really true. I think more likely is what happens is that in fact we just are overcommitted. We try to do too many things. We have too many cases open. And therefore, there's a real tendency, particularly when you get one of these from the court, to put it down at the bottom of the pile and say, well, you know, it's not really a case I wanted, so I'll get to it later. I urge not to do that. There are statute of limitations in these cases. You want to make sure you have all the right defendants. So like any other brand new case you're taking on, it behooves you to take a few minutes when you get that appointment to pull down the docket sheet, figure out what's going on, and make yourself a plan as to what's going to happen. The other reason to do that is because prisoners get noticed when you're appointed to represent them. They will know that you were appointed. So if they don't hear from you, then they're going to wonder what's going on. They may write the judge saying, hey, you know, I got this notice saying John Smith was appointed to represent me, and I never heard from John Smith. So it's good to reach out. There's a question in the Q&A saying, if you're appointed, can you decline the appointment? There are some narrow grounds to decline it, which are set forth in the respective rules for the Northern and Southern District. But I will tell you, one of the grounds for declining it is not that you don't have background in prisoner civil rights work. If you're a member of the bar, then it's assumed that you can take on these cases, and that's why I'm here. In the materials that we circulated, there is also lots of other available useful information, handbooks, etc., which you can look to, but you can also contact me on an ongoing basis. This is not a one-time seminar. If you go through your case, then you are allowed to contact me, and my email address is provided in the materials and may also have been in the order that it was appointed to. There's a second question in the Q&A about costs. There is a provision in both the Northern and Southern District rules for provision of some funds to defray the costs of taking on these cases. There are procedures which differ somewhat between the two districts as to how you access those funds, but the court does have a fund which can help you pay for things like depositions and in some cases experts. But I will say in advance that experts tend to be more expensive than the budget that's allowed by the court. And one of the things we'll be addressing today is how you can do some of those things without experts. Depending on the case, I'm not going to tell you that you can always get away with an expert. But yes, there is some money out there for that. I would say the other thing I want to say in a sort of introductory note here is that these are in some ways very challenging cases in the sense that you have what's commonly known in the tort business as a crippled case. That is, you have a client who starts off with 2.5 strikes against them. Sort of by definition, they're in prison. They've been convicted of a serious crime. Many times it's a very serious crime. You may be representing people who are convicted of murder or multiple murders or serving life sentences. Other times you get somebody who's only spending 30, 60 days in prison on a drug charge. But I would say the vast majority of prisoners who get lawyers appointed are serving serious time for serious offenses. So that's part of the goal today, is to talk about how we can deal with these cases and how you can build up the credibility of your client, despite the fact that they start off with a couple of strikes against them. But that's no different than a lot of the cases we already do, where we represent somebody in our private practices, where someone may not be the most attractive client. Maybe a big corporation that has done something wrong. It may be an individual who got fired for some misconduct. So whatever it is, that's the idea here, is to try to figure out how we can present our clients in a way that is most likely to prevail and most likely to overcome the disabilities we start with. And I've always said, if you can try a prisoner case and make your client here look good, then you can try any sort of civil case and make your client look good. We will talk about attorney-client agreements in a minute, so hold tight, the person who set that up. The first thing I want to say in terms of your clients here, you're dealing with prisoners. They're in prison, obviously, by definition. That is a very stressful place to be. Prison is an odd sort of place. It is mostly extraordinarily boring. You sit many people are sitting in their cells 22, 23 hours a day with nothing to do other than maybe stare at a TV if they're lucky to have a TV, or read if they're lucky enough to have had enough education so they're literate, or basically just stare at the wall. So that's an important thing to think and keep in mind. I know I myself have gotten lots and lots of letters from prisoners complaining about how terrible I'm doing and saying they never want to speak to me again. And then the next day they'll write me and ask me for help. You have to understand that, again, this is a high pressure situation they're under, and they're going to reach out for any sort of help that they can get. And sometimes you're a safe outlet for anger that they get there. So again, this is not your normal client attorney relationship. And you should keep that in mind when you're dealing with your clients, that they're under some great stress, and you shouldn't take what they say you personally. Sometimes it can be difficult. So the first thing that happens in a case is you'll get a nifty little order, which would look something like this. And this is something letting you know that you've been appointed. Lucky you, you hit the jackpot. You now have a prisoner as a client. This is not a voluntary relationship. Obviously, you didn't ask for this client to be yours, and the client didn't ask for you to be their lawyer. This is a case. The example that's on the screen is one where I was appointed personally by Judge Bucklow in the Northern District in order to represent a prisoner who had a medical care issue. When you get that, then the first thing you're going to want to do is take a look at the docket sheet and see what's already happened. As you can see from this particular order, this was the 192nd document that had been filed in this case. So obviously a lot had gone on before I was appointed. And that happens quite regularly, that things have gone on. Sometimes it's a lot. Sometimes they get appointed right at the beginning. You get appointed right at the beginning of the case and nothing's really happened other than that the court has looked at your client's complaint and said, oh, gee, this person obviously has something going on here. but needs to have some help. Nicole, you're back. You want to introduce yourself briefly?
Yeah, good morning, everyone. I'm Nicole Schultz. I'm the legal director at Uptown People's Law Center. We just filed 7 cases alleging sexual assault this morning. And so I'm going to be popping out a little bit this morning to talk to some press, which is very exciting. But I'm really glad to be here today and kind of riff off of Alan on some of my experiences. I've been at UPLC now for the past 14 years, starting right out of law school. Have really only done this work in my career. And Alan's been a great mentor to me, so it's fun to come and co-mentor with him, with all of you guys. Alan, while I've got the stage, I don't know if you're looking at the chat, but there's been some questions that come in about
You did.
appointed attorneys. If we
I've
want to,
answered them except for the last one, which we will get to the question about an attorney-client agreement in just a minute.
okay, great.
Coming up. So I think the first thing you need to do is figure out where your client is. It's rather important that you know where they are and how to communicate with them. And I'm going to talk a lot about the Illinois Department of Corrections because I think that is the majority of the cases. It's not going to translate directly if you have a case that's either a federal prisoner or a county detainee. That is someone who has not yet been convicted and is facing charges. Would be in county jail. Somebody who's been convicted in state law would be in the state prisons, the IDOC. And obviously somebody who's been convicted under a federal statute in federal court would be in the federal prison. So there will be I'll mention as we go along a couple things about both the counties and the federal system, but we are going to focus largely on the Illinois Department of Corrections. It's the system that Nicole and I know the best because we've spent 90% of our time litigating against the Illinois Department of Corrections. But I think most of what we're going to say is going to translate fairly well to the other two systems. There'll be differences. So the first thing, when you get one of these things, you're likely to say, what in the world do I do now? I'm completely lost. I have no idea what to do with a prisoner case. And that's our job today, is to give you a roadmap to figure out how to do this. Your client is waiting for you. So again, don't delay. Get going on the case. If you're wondering, if you don't get enough here, there are resources in both the Northern and the Southern District as to tons of resources for people who are appointed to these cases. Take a look at those if you need some additional information. Look at the docket sheet. As I said earlier, there will be a whole series of things that have happened on the docket sheet, and you want to figure out where your case is. That's really important. In particular, you are going to want to look at what is known as the screening order or something along those lines. It won't necessarily be called that. Prisoner cases are unlike any other case. Before a prisoner can actually file a complaint in federal court, it has to be reviewed by a judge to determine whether or not the complaint states a cause of action, whether or not the people who are sued are subject to being sued, and otherwise whether or not it, at least at a very broad level, states a cause of action. Generally, there will be a detailed breakdown of exactly what claims the judge thinks are there, and that is the important part to look at. So this is one that was done by Judge St. Eve. The Northern District tends to have fairly summary sorts of orders like this, saying, yeah, it looks like it states a cause of action. The Southern District judges tend to be much more detailed and may break down the often rambling complaints into individual counts, may dismiss a bunch of individual defendants. In some cases, both districts will actually say, this complaint itself doesn't state a cause of action, so I'm going to dismiss the complaint, not the case, but the complaint, and I'm going to appoint a lawyer to file an amended complaint. So again, you want to look at these things. If you have one of these screening orders, which will be in almost every case, you're going to look at it. It's not the be all and end all. Obviously, the judge is basing their decision on what the prisoner put in their complaint, and prisoners don't necessarily know what has to be in a complaint in order to state a cause of action. So this gives you an idea of how the judge is reading the current complaint, but that doesn't mean that there aren't other claims that the client could have brought and didn't know about. For example, we fairly regularly get complaints that also may raise an Americans with Disabilities Act claim. In fact, Nikki, we'll talk more this afternoon about the Rodesky case, but that's one that started off really as an Eighth Amendment case and ended up being mostly an ADA case. Nikki, you want to tell us a little bit about how that happened?
Yeah, so I mean, I think one thing I wanted to point out in these merit review orders is what I call them, is that just because a judge dismisses a claim does not mean there's not a claim there. I think that's really important to keep in mind because I know often we're rushed, we don't really know what we're doing and we see, oh, that's dismissed, I don't have to pay attention to it. But often it's just a matter of the way that issue was pled, and it doesn't mean that there's not a good claim on that. So just to really, really look in detail at what was actually written in the complaint and what was actually written in the review order to make sure that you're not missing any claims that are actually still viable. And in the Rodesky case, so it's as Alan mentioned, it started out as a medical care, lack of medical care case. But then as the issues progressed, because of the lack of medical care and the injuries that the our client sustained, he became eligible under the ADA because he wasn't able to walk. And then it became clear that the Department of Corrections was not providing him the proper accommodations and the fact that he had to walk up 4 flights of stairs twice a day to get his insulin, which is his diabetes is the cause of his injury. And so that's how the case transformed into an ADA case, which is a much cleaner cause of action than a that doesn't have the deliberate indifference standards. And the good bonus points is that the attorney's fees are not capped under the ADA, so we can get paid more as attorneys if when we win the case.
And we'll talk more about your ability to get fees later on, even though it's a pro bono case, you can in fact collect fees. So the second thing you need to do once you figure out what's going on in the case is figure out where your client is. The Illinois Department of Corrections, as well as most counties and certainly the Bureau of Prisons, has a very nice, detailed uh, section on its website that allows you to find your prisoner, either by their last name, and you can use the first name as well. If you have somebody like Smith, there's going to be a million Smiths, so you want to use a comma in their first name, or their IDOC number, or oddly enough, you can search by their birthday, which I've never found useful at all. But either the IDOC number, which would normally be in the complaint or on the docket sheet, or just by their last name or first name. So that will tell you a lot of information about your client, probably more than you wanted to know. It will also tell you something about the facility. It will tell you where the client is held, and therefore we'll be able to list the address of it, how you reach them. There'll be a telephone number on each prison has its own page on the Illinois Department of Corrections website. I'll have a telephone number as to how you can reach the prison and set up calls, etc., with your client. So we'll talk about doing that in a minute. It's really important, I think, that you write your client right away. Let them know that you've gotten the case, you've been appointed to the case, and you're reviewing the docket and reviewing what's going on with the case, and let him know that you will be in touch with him later and soon to talk about the details of the case. But your first letter is just an introduction saying, "Here I am." I think it's also very important to visit with your client at least once at the very beginning of the case. Now, when I say you, often it's a partner in a firm who's appointed, and the associates in the firm end up doing a lot of the work, which is completely fine. That's one of the great ways that young lawyers can get some trial practice or some discovery practice to hands-on client contact, is by taking on that burden. But I think it's also important that the person who's actually appointed at least make the initial contact with the prisoner. I've seen too many times when the prisoner has written back to the judge saying, "Hey, you sent me an order saying that John Smith was being appointed to represent me, and I've met with 5 different lawyers, but none of them were John Smith. So I'm wondering where the lawyer is who you said was going to represent me." So just to build that sort of relationship with your client, I think it's important that you be there at the first time. Sometimes these visits take a while, and not everybody's located close to your office. You're gonna have to drive to the prison. We'll talk about setting up visits in a minute. But I really think making that initial contact with the prisoner in a face-to-face meeting builds up the kind of relationship and the kind of relationship of trust, hopefully, that will make your dealings as you go forward in the case and may have to make some difficult decisions much more effective. So I urge you to go down and have a face-to-face meeting with your client as soon as possible. And you also have to remember that prisoners may be skeptical of your ability to represent them or your willingness to represent them. Remember, most of them have been convicted, all of them have been convicted, mostly represented by a public defender. And due to our underfunding of public defenders, they often don't have a lot of time to spend with individual clients. So often people will feel like they were sort of railroaded through the system and nobody ever listened to them, and they didn't get a chance to tell the judge anything, and they were sort of pressured into pleading guilty. And they may not think highly of the public defender they had. And now all of a sudden, here's another court-appointed lawyer, you, coming in and saying, "Oh, gee, you have to represent." Here's another court-appointed lawyer who's going to be just as bad as the other one. And I have found that if you go down and you meet with your client face to face, and you do this, right away, that all of a sudden you've been transformed from some sort of weirdly disassociated lawyer that was appointed to the court to all of a sudden the greatest lawyer in the world. You're the only lawyer that's ever sat down and talked to them face to face, let them tell their whole story, spend an hour just listening to them. That's something that rarely happens in the criminal courts, and it's something that will build you up a lot of credibility for you and the client. When you write your prisoners, it's important that you make it clear that this is a privileged legal communication or confidential correspondence. And there's two things that have to happen in order to make that happen. First of all, your individual name has to be on the return address for the letter. The reason for that is because one of the things the mailroom does is checks to see if a lawyer's letter is really from a lawyer. And to do that, they put your name into the ARDC database. And if you are from, say, Winston and Strawn, and they put in Winston and Strawn and see if Winston and Strawn is a licensed lawyer in the state of Illinois, it won't come back as a person, because of course it isn't. It's a firm. So if your individual name is in there, then if they should check, then they'll find out that in fact you are a lawyer. You also have to clearly mark on the outside of the envelope that it is in fact privileged legal correspondence, or words to that effect. Again, that's a signal to the mailroom that they're not supposed to open the mail and that this is a confidential communication. The third thing that's important on that envelope is to make sure you have your client's name and number exactly like it is on the IDOC website. The people in the mailroom are not in the least bit creative. If you were to address it to John Smith with a Y there, even with the right number, then they would be sent back to you as saying name and number don't match. So it's really important that you get their name exactly as it is. Many people use nicknames in the Department of Corrections. That won't do any good whatsoever on the envelope. There's some trans people who have a preferred name that they use within the Department of Corrections, but that is not their legal name on the department's website. So you have to address the outside of the envelope to their name as it appears on the IDOC website. The other reason it's important, aside from the privilege question, the other reason it's important to flag prisoner mail as confidential or privileged is that it gets treated differently in the mailroom. Particularly around holidays, it can take a long time for letters in the ordinary course to make it to a prisoner. During the Christmas time, it can take a month or more before those letters get actually delivered to the prisoner. But they're pretty good about pulling out all of the legal mail and getting that delivered right away. I don't know what your recent experience has been, Nikki, but I think it generally less than a week to get mail into prisoners.
It depends on the facilities. The maximum security prisons, Pontiac, Menard, Lawrence, are slower, but generally within the week, our clients get the mail we send.
So it just speeds things up. It gets pulled out of the thing. Now, you do have to understand, though, when you write these, it is not, I mean, it is a privileged communication. It's generally not open in the mailroom. However, they are opened when it gets to the cell. Guards are allowed to open the envelope in front of the prisoner, and it's supposed to be in front of the prisoner, to check to make sure really what's inside is from you and that there's no contraband in there. My favorite example of why they do this is from Tams when we had a Supermax prison. When somebody from the outside used a lawyer's return address, not mine, thankfully, and put some legal papers inside, but also included hacksaw blades inside. And for whatever reason, the guards did not open the envelope or opened it and didn't check very well. So the hacksaw blade actually got into the prisoner's hands being what was supposed to be legal mail, although it never came from a lawyer at all, which was very clear. So they do have the right to open it, and therefore they can look at it to see if it's legal mail. They're not supposed to read it. but I really wouldn't count on nobody being able to read it. The other thing that you should be aware of is that once it's in the cell, then it's subject to being cells are being subject to being searched at any time, and the prisoner is not there, so there is nothing to stop a guard who is going through a cell from reading the mail that's there. So you just want to be aware that while it is privileged mail, you don't want to put anything too inflammatory in there. Like if your client were to confess to a crime, for example, you wouldn't want to put that in writing and send it back to them, because that might fall into the wrong hands at some point. So you just want to be aware of what you're putting in writing as compared to what you cover in a telephone call or in a face-to-face meeting. I think the next thing we want to talk about, and this is a question that's in there, the question was, if you're appointed, can I enter into an attorney-client agreement such that it is no longer pro bono? Well, yes, you can enter into an attorney-client agreement, but it is still considered pro bono, again, because you have no guarantee of getting paid here. And we've gone through a retention letter, it should have been in the materials you were provided. If not, it will be right after the seminar here. And we have sort of a model that we put together of what a simple retainer agreement might look like. And there's some parts of it that I want to talk about here that I think are important to put in there. First of all is the scope of services. You are appointed to one case and one case only. It's really important that you lay out at the beginning, saying that, this is the case I'm appointed to. I'm not agreeing to take on any of your other cases. Now, obviously, you're welcome to take on other cases, and some prisoners may have a really good claim that you want to help them out with, just because you want to help them out. But nonetheless, you are only appointed to one, and you have no obligation to do other than the one case you're appointed to. Putting that in the agreement right at the beginning, I think, is really helpful as you go down the road. I have certainly seen all the time prisoners ask for you to do something else for them. It can be anything from they have an estate problem, their mom died, and they want to know what happened to her house. It could be another case they want to bring. It could be you name it. And there's nothing wrong with a prisoner asking. If I was in prison and had a lawyer who's paying attention to me, I'd ask him too. What do you got to lose? But it makes it easier to say no if you said from the very beginning, I'm only taking on this case. So I think that it's really important that you lay that out at the very beginning, that your appointment is for this case, and you're going to devote yourself heart and soul to this case, but that's the only case you're representing on.
Can I just make a quick comment here, Alan?
Absolutely.
I think it's also important to stick by that, because once you open that door, then the door is open and it's really hard to close it again. So it is so tempting to do these little things for our clients, especially when we know there's no one else that's going to able to do them. But you might get slogged down on doing all these little things, and lose focus on the case. So I think if you can make it work and just really stick by those boundaries, I think that will make your representation in this case much more effective.
Yeah, there was a comment in the question and answer which I think is important. It has happened to us, and I think a number of other lawyers as well, that one of the things the mailroom has been doing is calling the lawyer who sent it to confirm that in fact they did send the letter. So if you get such a call, don't freak out. They're just trying to confirm that in fact the letter from you is a letter that's sent in. We have a format that we use for all of our letters, which includes a big red stamp having the confidential stuff on it, making it much harder, therefore, to sort of forge our name as coming from somebody else. Obviously, somebody else could still buy a similar stamp and use it, but it would take a lot more effort to do so. And I think that's really cut down on a number of those calls we get, because people in the mailroom get used to our mail, and therefore they don't have a question as to whether or not we send it or not. Okay, the second thing I think is important to lay out here is how you're going to communicate with your client. It's important to understand the rules of ethics, and this is one of the things that often trips up lawyers. Is you are required under Illinois Rule of Professional Conduct, Rule 1.4, to keep your client informed as to what's going on in the case. So I think it's important there that you lay out here as to exactly how that communication is going to happen. Particularly here, and one of the things I've highlighted here is calls. This is a little bit out of date because they don't do collect calls anymore. But it's still important for you to lay out whether or not you're going to accept a call that the prisoner initiates or not. Our policy at Town People's Law Centers, we generally do not accept calls from prisoners that we do not initiate, partly because those are simply not going to be attorney-client. Those are not privileged calls in any way. They are recorded. They're on a line that says it's recorded, and therefore they are fair game for anybody to listen to, including the opposition in your case. So we don't want to do that, as well as just cutting down on the number of calls. So I
And
think
Alan,
that,
with this, I also want to just highlight that oftentimes prisoners will call their family members and do what's called a three-way call and try and loop us in. And those are very bad because number one, they are also recorded. But number two, that's also a disciplinary ticket for the prisoner and could and make it so you can't make legal calls with the prisoners either. So just be really careful on those kinds of calls too. I generally just like shut it down. I'm like, I can't make these. I can't talk like this. This will ruin our ability to talk confidentiality. And I just hang up the phone and then try and set up a legal call as soon as I can thereafter with the client.
and the same as the other way around. That is often, sometimes prisoners will call you and ask you to set up a three-way call, looping in a family member. And again, the answer has to be no. That is a violation of the state rules, and it can lead to your being banned from talking to your clients confidentially on the phones altogether. It's an abuse of privileges. Obviously, the reason that they're allowed to call you on a secure line is because you're their lawyer. And if you're using that line for some reason other than talking about legal matters, then it's clearly an abuse, and they can cut you down. So third-party calls are generally not going to be allowed at all. They've had to loosen that up a little bit in terms of being able to loop in a couple of different lawyers who are on the same call. So we've certainly had lawyers join from two different locations into one call. That should be disclosed in advance that you're going to do that. In theory, the computers that monitor all these calls will be able to figure out whether or not there's another person on the line. And again, you just don't want to be caught violating the rules. So again, the other piece of communication here is email or instant messaging. Again, our letter is a little out of date here because we don't deal with that because it's a relatively recent phenomenon that prisoners do have access to messaging. Again, our position at the Uptown People's Law Center is, with some very few exceptions, we do not accept emails or instant messaging or whatever they call it these days from prisoners. Those are not confidential ever. They're all subject to being reviewed by the Department of Corrections, and they do review those quite regularly. And then we have a few clients that we will accept it from. And Nikki, you do that more than I do. So explain how you make that decision.
I really base it on my knowledge, my relationship with a client. If it's people I've known for several years and know that they understand the differences between privileged and not privileged information, I will set up an email with them and basically say, this is used for you to tell me you need a legal call. We don't share any information in it. We don't. And if you start sharing what I consider should be privileged information, I'm going to shut this down. There's other clients that I just if it's someone I don't know that they don't understand that differences, I won't set up an email. And then there's other clients where I'm like, I know for a fact you don't understand these differences. And so I'm not going to set this email up. And I keep it kind of close to my chest on that I actually email other people because I don't like to have different rules for different clients. But I'm very, very, very particular about who I allow to email us, and am very quick to shut it down.
Yeah, I would say of the probably 10,000 class members that we represent in various cases, you're at less than 5 or 6 people.
And I haven't set up any new emails since they got the new system because it's not been that effective.
Okay. Right. That's the other thing. I think that it's not like your email where they get it instantly. There's a long delay, and they seem to get all of these messages seem to be reviewed by somebody in the Department of Corrections before they are delivered. So it's really it's not speedy. It's not like they're going to get an email and then they can respond right away anyway.
Yeah, I think it usually takes 2 days, and I have had clients who email me and get that email kicked back because it contains some kind of information that the department didn't want me to have. Generally, it's like other people in custody's names.
Okay, so the final thing that I want to talk about here are fees. And this goes back to the original question that was asked here. Can you enter into a fee agreement with your client? Yes, you can. The American Bar Association and various other professional organizations, in fact, encourage lawyers to take fees in these cases, both as an incentive to take the cases, but also your fees can be a bargaining tool in order to try to, when you come to settlement, it's not just the damages the client's going to get, but your fees may also go into the calculation for the defendants. There is an exception. There is one note, though, in the Northern District. Fee agreements cannot be enforced until the court approves them. So they can get appointed. I mean, they can be submitted to the court in camera as a sealed document, and then the court will review it and see whether or not it's fair or not. I have never had one turned down, but that is in fact the rule. The Southern District does not have a similar rule. Nikki, you want to answer a question about communication with people who have been transferred?
Oh, well, I was just looking at that question, and I'm assuming this is the client who got transferred to Colorado, and that's the Federal Bureau of Prisons, and I don't have a good answer for that one. I think I've done, as Alan mentioned, most of our work is in this Illinois state prisons. We've done very limited work in the federal prisons, but I think it does depend on the prison. I think the policies are maybe the same, but it depends on who is setting up the calls.
Yeah.
And how they communicate. So I think it is specific to the prisons. And I've noticed that higher security BOP prisons make it much more difficult than the lower security prisons.
I will add that every federal prison has a lawyer, as it were, assigned to that prison, an in-house lawyer from the Bureau of Prison, and that's the person. If you really can't get through to a client, then you can seek to have those lawyers intervene. I think they're generally listed on the IDOC website, on the Bureau of Prison website for that individual prison. And if not, the general number will be there, and you can ask to talk to the attorney who's in charge. So there are ways to get through that in the federal system. It is usually the counselor who sets up those calls. And as Nikki said, some of them are great and some of them are horrible. And I'm sure it varies by facility. And the other option, and this doesn't just apply to the federal, but it applies to any communication problems you have with your client. If the prison system is making it difficult or impossible for you to communicate with your client, your ultimate solution is always to go back to the judge who appointed you and ask for assistance. And you know, it's a fair thing to do. The judge appointed you, so they have some skin in the game to make sure you can actually do your job. So if you're really just hitting a brick wall and you've tried everything you can to communicate with your client, and the prison is just not cooperating and not letting you get through, and you can't figure out what you're supposed to do, file a motion with the judge saying, you know, Judge, I'm at a loss here. You appointed me to represent this client. I can't get through to them. Can you help me out? And often that will be enough to get you a call or a visit or whatever they're trying to do. No prison wants to have the judge on their bad side. And again, you're appointed. You're here involuntarily. So I think judges have some real sympathy for you as a involuntary lawyer here. That they will try to do anything they can to help you out within obviously the limits of what lawyers can do. There's another question here about people who don't speak English, or at least not the same language as the person who was appointed. I think that both the Northern and Southern District have a separate pot of money to pay for interpreters or translators. That does not come out of the general fund. That's a separate line item, and they are more than happy to pay for a translator. Normally that works with a three-way communication, and again, it's an exception to the three-way rule, something you have to arrange for the prison in advance. But just tell them you're gonna have a translator on there and a three-way call so that they can be on the call with you. So that is something that's available by a separate pot of money, which the district court will reimburse you for the cost of communicating with somebody who doesn't speak English or doesn't speak the same language as the lawyer appointed. There's a second question in here. What happens if the inmate refuses to sign this fee agreement? Generally, what I've seen lawyers do, it's never happened to me. What I've seen lawyers do is, again, just bring that to the attention of the judge. Judges have been known to set up a three-way call with the lawyer and the client, tell the client to sign the damn thing. which generally works. And if they still absolutely refuse to do it, then what the judge generally will do is tell the client, you have two choices here. Either you're going to sign this, or you don't have to sign it. You don't have to have this lawyer, but I'm not going to appoint somebody else. The judge will generally explain this is a very reasonable agreement, and they should do it. So again, I think that's that again, your judge that appointed you is the person who can be the most helpful in working through all those things. Another good point here that was raised in the chat here, or the question and answer, there are Zoom calls that can be set up by the Cook County Jail, and they are also confidential. You do want to make sure that you, with legal calls as well as Zoom calls or anything else, the first thing I always ask the client is, are you alone in the room? Oddly enough, even though when they're set up as attorney-client calls, there will often be times where a guard insists on sitting in the room. Generally, it works fine if you just tell the prisoner to hand over the phone to the person who's in the room, remind them it's a confidential legal call, and they are entitled to have visual contact with the client, but not hear what they have to say. That generally works. If it doesn't work, then I would hang up and reset up the call, and we'll talk about the mechanics of setting up the call in a minute. But generally, the second time through will solve that problem. There's no question that you have the right to be there in the room, or the client has the right to be in the room alone when they're talking to you. So it's important to enforce that rule from the beginning. So make sure that that's true. Question, who pays the fees? And that's really the same question as who pays the damages. In general, all Department of Corrections employees are defended by the Attorney General's office, which is appointed to represent them, and they will cover any award of damages or attorney's fees is also paid by the state. That is both a state statute as well as a provision in the union contract between the union and the guards. So there are a couple of occasions, including one Nikki's handling right now, or two Nikki's handling right now, where the Department of Corrections has said, no, we're not reimbursing. And Nikki, you want to tell us how does that happen?
So generally those instances they are few and far between, but it is when the correctional officer most generally has, done something that is outside the scope of their employment. In my cases, they're all sexual assault cases. So the guard raped our client and the department kind of cuts him loose. Most of these guards have also been fired at some point in time eventually once they get through the union process. And that makes it more complicated, quite honestly, because number one, collecting on these because the state's not paying is a problem. The pockets that an individual guard who maybe has lost their job are not very deep. And you're also dealing with an attorney or maybe no attorney. In one case, the guard defaulted and never even tried to defend himself. But in the other case, you're dealing with an attorney who doesn't know these cases, which is, sometimes more difficult because they don't know what you're doing. You might not know what you're doing, and everything's a hot mess. Um, but that's why I think when we're talking about like amending the complaint and the complaint, like thinking about other potential plaintiffs that will be represented by the state can get your client more money in the long run, even if their claims aren't as strong because of the indemnification that happens.
But even in those cases, while they didn't defend or reimburse the guard, they did continue to represent and reimburse the higher ups.
Right, exactly. So if you can sue someone for a failure to protect the warden for whatever happened to your client, then the state generally represents and indemnifies those individuals as long as, it's not like an egregious failure outside the scope of their employment. The state generally will defend everyone.
Yeah, I have never heard of the state dumping a warden or higher.
Yeah.
In any case, it's almost always line officers who are the ones.
Line officers, right. And it's like egregious conduct. This is like really, because line officers, the state they'll get away with all kinds of stuff and the state still represents them. And I've never heard of a medical person not being represented by either the state or the private contractor.
Yeah. So a couple so while a written fee agreement is not required under the local rules, It is also, remember, the Illinois Rules of Professional Conduct strongly encourage, but do not require, written fee agreements. So again, I think it's really important that you, even if you're not going to charge a fee, and some firms don't want to charge fees in these cases for whatever reason, that's up to them. But even if you're not going to charge a fee, I think it's important to start off laying out the ground rules as to the scope of your representation, how you're going to communicate with the client, etc. And I just think that that's absolutely important. It's also important, I think, because some of the other rules, including division responsibility. So, you know, it's important to keep in mind the prisoner is allowed to demand things in a case which are unreasonable. If a prisoner says, I want this case to go to trial unless they offer me $500,000. You may think this is a case that's only worth $5,000 and think it's ridiculous, but they get to make that decision. And if they want to go to trial in a case that you think is a valid case, you can't obviously violate Rule 11, but you think that they're grossly misvaluing it, you can certainly use all of your skills as a negotiator to try to persuade them otherwise. But if they insist, then go to trial. And again, that's where that communication that you build up with the client at the very beginning and the bounds of trust at the very beginning are so important. Often prisoners may think, well, he's just trying to get out of this case. He's trying to get me to settle cheap. It's a $100,000 case, and he wants me to take $5,000, and that's just because he doesn't want to do the work. So I think it's important to understand how these things are, how the allocation of responsibility is. The clients get to make the decisions about the goals in the case and what they're pursuing. You get to make the decisions as to how you're going to pursue that case. So they obviously don't get to write the discovery questions for you or tell you what you have to ask in depositions. But I will also say, some of these prisoners have spent a long time thinking about their case. And certainly as to the facts of the case, they're much more likely to know that it's far better than you are, regardless of how much time you spend on it. So I think that it's really important that you do listen to your client, but also keep in mind exactly how the rules of ethics divide up the capacity between you and your client.
Kind of on that note, a lot of the individuals we represent are incredibly intelligent human beings who know more about how the prison works than any of us do, kind of what Alan said. And I've like sent deposition transcripts to clients and been like, what do you think about this? And we sit down and actually work together on kind of our trial plan based on the discovery we've gotten. So really, really, work with the client and not for the client, I think is a good theme, a good thought to have.
Somebody asked how you can volunteer to be appointed to a case. Yes, contact the clerk in either district, and they will be happy to put you on the list of getting appointed. In the Southern District, there's actually a pro bono list. In the Northern District, just call up the clerk's office and say, I want to be appointed to a case, and they will appoint you. No question about it. There's no shortage of cases where the prisoner would love to have a lawyer. So it's never a problem finding you a case if you want one. Okay, let's talk about visiting the client. So obviously this is not a client that you can just call up and say, come into your office and meet like any other client would be. Instead, this is a situation where you have to go to the client. How do you arrange those things? Well, every prison has something like a legal coordinator, a legal liaison. They seem to have different names in different prisons. But there's a person who's responsible for figuring out legal calls and legal visits with your client. Be really nice to them. They can make your life really easy, or they make it really difficult. So think carefully about how you deal with them. Generally, what you're going to do is call the prison, ask to talk to the legal liaison or the litigation coordinator about a legal visit. Get some idea from them as to what the hours are that they're allowed to visit, if there are any dates that are blocked out, how much time they need advance notice. Generally, it's a minimum of 24 hours. Although some prisons are backed up, so you may not get a date for a couple of weeks. And then ultimately, they'll want to have you make a request in writing on your letterhead or on their own form asking for a legal visit. So I think that that's really important to do. If this had been a year ago, I would have said at your legal visit, there's absolutely no way you're going to be allowed to bring in any electronics at all. No laptops, no cell phones, no nothing. Some prisons don't even allow you to bring a watch in. But Nikki has been able to work some magic and now is getting some of that stuff improved. So tell us how you magically get more than I ever got.
I ask is the simple answer. I mean, you're never going to get a cell phone or an Apple smartwatch or those kinds of things in, but in every single prison legal visit request I make these days, I ask to bring a laptop in. I ask to bring a bottle of water in. I ask to bring like a granola bar, a banana in, because sometimes you're there for a couple hours. I often group my visits together and see as many people at that prison as I can. So I might do 5 visits in one day, which means I'm in that prison for 5 or 6 hours. If you ask, you might get it. There's some facilities that almost always give me a laptop. Logan almost always gives me a laptop. Juliet almost always gives me a laptop. We recently got laptops into Lawrence, which I was surprised because it's a maximum security prison. Menard will never give you a laptop. But if you don't ask, you don't know. And I think the key is the sooner you make your the longer out you make your visit request to give them time to get these things approved, the more likely you're going to get it because for laptops, for sure, it needs warden approval, which takes some time. So I think make your visit request earlier rather than later and just ask and see what happens.
Other things that vary by prison tremendously. Some prisons don't want you to bring staples, as stapled papers together. So no staples are allowed in some prisons, but are allowed in others. Some prisons will not allow you to bring in a old-fashioned spiral notebook that has a little metal binding on it. Like Menard is terrible about that. Other prisons couldn't care less. So again, just to ask the prison that this is where the litigation coordinator person becomes so important. Just ask in advance what you can bring in. If you're going to bring legal materials, or you want your client to bring up legal materials to the visit, that should be in the request. Remember what happens here mechanically is this request is then transformed into what's called a gate pass and will be at the front desk. And at some prisons will be at various places you have to check in along the way to get to the visiting room. And if it's not listed on the gate pass, then you're not going to be allowed to get it in. So again, you want to make sure you make that request in writing and see whether or not it's approved or not. And that includes legal materials. Unfortunately, I've had far too often prisoners come up to a visit and said, I tried to bring up the key document in my case, but the guard said I wasn't allowed to bring anything with me because it didn't say so. So again, if you want your client to bring up materials, then ask for that in advance. If you're going to have them sign things during it, I would put that in the request as well, saying we're going to have to sign things back and forth, so we have to have a way to do that.
And also include that they can bring things back with them. That's the thing I often forget. And then I bring a bunch of paperwork for the client to have, and I can't give it to them. So that's another one to make sure you get specified. Um,
Yeah, a very key comment here in the question and answer, which is when you're in the visiting room, you have no access to water or bathroom facilities. So again, if you're going to have a long visit, you probably want a bottle of water in with you. Ask in advance whether or not you can bring in a bottle of water. And generally, they have now been saying yes, in large part because the water in the prisons is horrific, and they don't really want you drinking it. The guards never drink the water in the prisons. They all bring in bottles of their own water. So they have recently been allowing us to bring in water to the visits. And there's no bathroom facilities. If you have to go to the bathroom in the middle of your visit, you're going all the way back out to the front, and you have to go through the whole search and come through the whole process again. So go to the bathroom before you start.
and the bathrooms are not great.
Yeah.
Yeah, I'd say 50% chance there's toilet paper and paper towels in them.
And then somebody else asks how often are you going to have to visit the prison? It's going to depend a lot on how well your prisoner communicates in writing, how well you can do things on the phone. I would say 2 or 3 visits is absolutely crucial if it goes all the way to trial. Your initial visit is going to be important. You're going to have to go through interrogatory answers, which are generally done in person, I think, most effectively. Just doing that in writing takes forever. Go back and forth, and doing it over the phone is difficult because often you want to see the actual written words, and it's hard to do that over the phone. And then to prepare somebody's testimony, I've always found you have to do that in person. Other than that, though, a lot of this can be done by phone. So yes, many of the prisons are far away, but I don't think you're going to be going back and forth there every week or two. You're talking about 2 or 3 times during the course of your representation of a prisoner. So the mechanics, some prisons are going to have old-fashioned where you don't talk on directly to prisons using a telephone to communicate, or some other speaker sort of thing, so that you can communicate only through glass. I would say in 90% of the prisons that's not true. That's only going to be true, probably only true at the maximum security prisons, where excuse me, where your client is in solitary or in segregation. Generally, it's going to be a face-to-face visit. Menard being the exception, where they're all non-contact visits, like very much like this. You're in a little booth, but most of the other prisons will allow face-to-face communications between the client and the lawyer. Telephone calls also should be set up by you. As I said before, prisoners do have the ability to call you on your office line, but we discourage that. And again, the process for setting up a legal call is very much like the process for setting up a visit. Call up the litigation coordinator, ask them what sorts of times are available, put it in writing, and then they will send you an approval. And generally, they'll give you a specific time and a specific phone number and extension to call. And generally, your prisoner will be sitting there waiting for you when your call is ready to go. So it used to be that your prisoner would have to call you. That's no longer true. You can call into the prison. It used to be true you couldn't use a cell phone. That's not true anymore either. Cell phones are okay for legal calls now because everybody's using them. All right, the next topic I was going to talk about is exhaustion of administrative remedies. But before we do that, I think that we are going to take a small detour here. And since now you've got your client, you're ready to go, you understand what the case is about. So I think that it's time that we bring in somebody from the court itself to talk about mediation. Are you on the line?
I am.
Introduce yourself and tell us what this is all about.
Thank you. Thanks, Alan. My name is Megan Arvola. I'm the court attorney and the mediation coordinator here at the Southern District of Illinois. So I'll just talk very briefly about our program, how it applies to prisoner civil rights cases, but really my goal is just to get you my contact information in case you'd like to talk further. Anyone, please feel free to reach out to me at any time. So can you do the slides, Alan? Thank you. So just, again, super general, we have a mediation program here in the Southern District that was first implemented in October of 21. So it was first an admin order. Now it is Appendix C to our local rules, effective on Monday, September 22nd. So if you want to see our plan, it's on our local rules page, or also we have a mediation page dedicated to our mediation program specifically. And then the next one. Thank you. So general mediation program, something different. I'm going to talk now just briefly about how that plan applies to our prisoner civil rights cases. So most civil cases are automatically referred to mediation that are filed. Certain types are not. They are discretionary mediations, including prisoner civil rights, pro se cases generally, class actions, things like that. Those are not going to be automatically referred to mediation. This happens discretionary at different times in the case. I'll say generally, it will be post-exhaustion. I know Alan's going to talk about exhaustion here coming up. And there has been some like exchange of merits discovery. That's usually when prisoner civil rights cases are referred to mediation, but it can be before, it can be after. It really depends on the case. Okay, so once you have a mediation referral, discretionary one, entered in a case where you're representing a party pro bono, so who serves as the mediator? In prisoner civil rights cases, specifically, the court appoints a mediator, and the court could choose a mediator from our private mediator panel or the mediation coordinator, which is me. So I'm a court mediator as well. So who pays for those costs? With me, I'm an employee of the court, so there's no cost for my services. In the case of a private mediator, so any party who is IFP, informa pauperis, they are relieved from their pro rata share of the mediator's fee. Also, any private member of our mediation panel is, as a part of that membership, agrees to serve pro bono 1 mediation per year. So there is potentially that option as well. So once a case
I
is
think everybody who's appointed, every case where there's an appointed lawyer is automatically going to be an IFD case.
right, yep, right. Can a party move to opt out? Yes. So motions to opt out. So either side could move to opt out of the mediation. If that will be granted, it's in the discretion of the judge and it's for good cause, which can be different things, of course. This is just some super general stats about mediations for prisoner civil rights cases in our court. So as of now, about 157 prisoner civil rights cases have been referred to mediation. And this is, it usually is with me as the mediation coordinator. 72 of those have settled, either partially or in total. And 70% of those have been pre-summary judgment on the merits. So that means that some of them are post-summary judgment, closer to trial. But generally, we mediate in that pre-summary judgment phase. And that's it. That's it. I just want you to have my contact information. If you think mediation is something that your client, the other side especially, would like to be considered for, talk about, just give me a call, email me anytime. And that's it.
Thank you. And for those of you in the Northern District, there is a similar but quite differently structured, but the same goal, the Settlement Assistance Project, where magistrate judges can refer a case out to a private appointed lawyer just for settlement purposes. Some of the people on this call are probably involved with that program as well. So that again is a limited appointment where you're appointed as a lawyer just to represent people in a settlement posture rather than being appointed for the full case. So that is another option that happens in the Northern District, just so you're aware of that. I was talking about, before we broke, we were about to talk about the exhaustion of administrative remedies. But before that, I see a couple of questions I wanted to respond to. In terms of the litigation coordinator, the other thing that they're going to be important in doing is when you set up a deposition, if you're going to do a deposition in person at a prison, then the court reporter is going to have to come in. And you're going to need a list of all of the equipment that the court reporter is bringing. So work with your court reporters to make sure that all of the equipment they need is approved in advance. You don't want the worst possible situation is you've arranged for the deposition to be taken at the prison, and all of a sudden the court reporter is not allowed in with whatever crucial piece of equipment they have because nobody's approved it. And usually those are the kinds of things you can work out on the spot, but it's way better to have it all worked out in advance. It's a waste of everybody's time to show up for deposition and not have a court reporter. These days, a lot of those depositions are done remotely, where the court reporter is not in the same place is not in the prison at all. Rather they're in their office. This has been obviously different since COVID. So I think that's important to understand. Okay, let me move on to exhaustion of administrative remedies now. So again, prisoners are different than other civil litigants. Before they can bring a case in federal court, they have to have exhausted the available administrative remedies. And this is, I put on the screen here, the portion of the Prison Litigation Reform Act. There are many different sections of the Prison Litigation Reform Act, and you'll see it coming up from time to time during this presentation. But just so you're aware, this is one of the provisions that gets litigated more than any other, is whether or not prisoners have actually exhausted these administrative remedies. And there are several different sections here which are crucial. And I've highlighted those in red. So the first is no action shall be brought, meaning it doesn't matter if you exhaust your administrative remedies after the complaint is filed. It doesn't matter whether or not the exhaustion is going to be useless, because 85 other prisoners have filed the same grievance and they all got rejected. You have to have exhausted your client has to have exhausted administrative remedies before a lawsuit is filed. It's a lawsuit relating to prison conditions. So again, that used to be some debate about what exactly counted as a prison condition, but the Supreme Court has now made it very clear that a prison condition refers to anything that happens in a prison. So getting beat up by a guard is a prison condition. Having your mail censored is a prison condition. Being denied your religious rights is a prison condition. So all of those things are now prison conditions. So basically anything that you're going to be suing about is going to be subject to the exhaustion of administrative remedy. The third key provision is it has to be a suit brought by a prisoner. So if your client is released, but everything happened in prison, then it doesn't matter. What matters is whether they were a prisoner the day the case was filed. So to use a sort of silly example, somebody's in Cook County Jail, they get beat up by a guard, they bail out the next day, file that lawsuit. The day after that, their bail is revoked because they screwed up somehow. They're convicted and they serve a life sentence. That case is not brought by a prisoner because on the day that they filed the case, they were not in prison. Similarly, if you have a case where there's some question about exhaustion of administrative remedies, it was filed while your client was in prison, but now they've been released, you may want to consider the possibility of dismissing that case voluntarily and refiling now when they're not a prisoner. That avoids that entire fight. We did this in a case, again, a sexual assault case. We had a big fight about whether or not our client had properly exhausted administrative remedies. Then she was released. We simply moved to dismiss the case, refile it again, and the question of exhaustion then became moot. So again, the key question is whether they were a prisoner on the day the lawsuit gets filed. And then the other key things are available. Available means that the prisoner has to do whatever the rules provide for, but nothing more. So often, and we'll talk about this in more detail later, but basically, if, for example, they file agreements and nobody ever responds, then the remedies weren't available because prison officials can't avoid being sued just by never answering grievances. Exhaustion means you have to go through all of the administrative steps that there are, and we'll talk about what those are in a minute in the various systems. So it's not enough to have just filed a grievance. You have to take all the appeals that are available. You do not have to go to state court or file anything outside of the administrative system. It's just within the prison system itself. You have to file whatever remedies and whatever appeals there are within the system. So what does that look like in Illinois? It's a multiple step process in Illinois. And I've put on the screen here what happens. There's an injury. You file your grievance is initially filed with the counselor. The counselor makes a response, sends that back to the prisoner. If the prisoner is not satisfied with the response, then they can file it with the grievance officer. The grievance officer then makes a recommendation to the warden. The warden then makes a decision on whether or not to grant or deny the grievance. That's then returned to the prisoner. If the prisoner is still not satisfied, they can appeal to Springfield, what's called the Administrative Review Board, which is just a body of people who deal with grievance appeals. The Administrative Review Board makes a recommendation to the director, and the director makes the final decision, which is sent back to the prisoner. If you have a final decision, so one of the first things you want to do when you talk to your client is, do I have a piece of paper that counts as a final decision by the director? If you've got that golden piece of paper, then great. You don't have to worry about this issue at all. You've satisfied your obligations and you can move forward. If you don't, then you have to figure out what went wrong. Now, if the answer is my client never filed a grievance, then you might as well, I mean, it's an affirmative defense, let's be clear. It's an affirmative defense, so it's not something that you have to plead or your client has to plead. It's up to the defendants to raise it as an affirmative defense, and they have the burden of not only pleading, but of proof. So you shouldn't just dismiss a case, but you're going to have a serious talk with your client about how this case is likely to get dismissed. I have not seen any cases recently where the defendants have waived failure to file a grievance or failure to exhaust the entire process. So be aware, and this is one of the first things you want to start talking to your client about, unless it's already been resolved, in which case, again, is why you want to look at that docket sheet when you're first appointed to see whether or not, in fact, they've been exhausted or not. This is what a grievance looks like. This is the form that you get from the, I'm sorry, this is not a grievance. This is the final answer you get from the director. As you can see, in this case, it was denied. It was signed off on by the director and administrative review board person. You should be aware that In general, it's not actually the warden or the director who deals with grievances. They are allowed to and always do, or almost always do, delegate that responsibility to somebody else in their offices. As one warden testified in one of my cases, if I reviewed every grievance, I would do nothing else other than review grievances all day long. So generally, there's somebody at the office who in the warden's office who's responsible for reviewing and deciding grievances, not the warden themselves. Similarly, at the director level, the director almost never will look at a grievance. It's really just another member of the administrative review board who is delegated by the director to sign off on behalf of the director for grievances. So it's not like because you filed a grievance that the director and the warden personally know about this issue. That's not going to be enough in general to hold them responsible for what happened. Jails do not have a standard grievance process. Every jail has a different process, and a few jails in Illinois still don't have any grievance process at all. You're going to want to get those local rules. The Illinois rules are a matter of are on the part of the administrative code, so they're publicly available. The Cook County rules are not, but they are available on the UPLC website. And you can always FOIA them, or you can always ask the defendants for a copy of the rules that apply if they're going to raise this as an affirmative defense. But you do want to figure out what those rules are very quickly. The Bureau of Prisons has a similar system to what we have in Illinois here. It's again a four-step process. The big difference between the Bureau of Prison grievance process and the Illinois process is that the Bureau of Prisons has a rule saying that if there's not a decision within X number of days, and it's different at each step, then it's deemed denied and you can go on to the next step. Illinois does not have such a rule. And that means that there's no deadline after which you can firmly say this grievance has been denied. So that leaves you with sort of a conundrum here as to how, or leaves a prisoner, or if you're filing a complaint, how long you should wait. My favorite case is one we filed where the defendants argued in the alternative that one, we had filed too soon because the grievance hadn't been decided yet. And in the alternative, we had waited too long because it had obviously been denied, and therefore we had blown the statute of limitations. And the statute of limitations comes into this because during the time a grievance is pending, the statute of limitations does not run. So that means there's some wiggle room in the usual statute of limitations here, which, by the way, in Illinois is a 2-year statute of limitations. They import the state tort rule is what gets imported. The other thing to remember if you're doing federal work is there are 2 different ways to bring these claims. One is through the traditional Bivens complaint, that is, they violated the Constitution. Bivens is becoming vanishingly narrow, and I suspect within the next few years it may disappear altogether. And therefore, the alternative is the Federal Tort Claims Act, and there is a separate exhaustion process for that. So you want to be aware. You want to again be aware if you're going to bring a federal claim under the Federal Tort Claims Act, then this only applies to federal prisoners. So if you have a state or county prisoner, this is irrelevant. But there's a whole separate form that has to be filled out in order to protect your claim under the Federal Tort Claims Act. So be aware for federal prisons, there's 2 parallel systems they have to complete. It seems like a total waste of time to me, but that is the rules that have been applied, and the Supreme Court has agreed that they both apply. So I would definitely start doing this immediately. These are things that need to be resolved early on. We provided you with a copy of the Pavey case. Pavey made it clear in the 7th Circuit back in 2008 that issues regarding exhaustion are supposed to be addressed at the beginning of a case before substantive discovery happens, or certainly before things like motions to dismiss or other similar sorts of things are done. It should be done immediately. And frankly, from your point of view, you want it to be. You don't want to waste a lot of time on a case, which is also going to get thrown out on the fact that your client didn't exhaust administrative remedies. So that's one of the first things you want to talk to your client. The Southern District is pretty good if the defendants have raised failure to exhaust in their as an affirmative defense in their answer, then the Southern District generally sends out a form order requiring them setting a briefing schedule and requiring the defendants to produce particular materials. The Northern District does not have such a system. Therefore, I think it behooves you as the lawyer representing the client, if they have raised that as an affirmative defense, is to communicate immediately with the Attorney General or whoever's representing the defendants to see whether or not they're serious about that, and if so, to work out a discovery schedule and a hearing schedule and a briefing schedule to get this issue resolved. That used to be really clear, but just this year, the Supreme Court, in a case called Per2, which is in the written materials we provided you, has said that when the issue of whether or not it is exhaustion is entangled with the merits, then prisoners have a right to have a jury determine that issue. So, for example, if your claim is your client claims they were seriously injured such that they really couldn't complete the grievance process, then clearly the seriousness of their injury is entangled with their underlying claim, as well as can be excused for not exhausting administrative remedies. Therefore, that would be something that was entitled to go to the jury and have the jury decide whether or not their disability was such that they could not meaningfully exhaust. If you have a case where exhaustion becomes an issue, I have a lot more information on this. I have a whole PowerPoint presentation and handout that goes with that. Contact me and I'll send it to you. Most of the cases that you're appointed to are going to have this issue resolved before you're appointed, so I'm not spending a lot of time on it here on all the details, but just be aware that there are lots of ways you can fight back. If your client does not have that golden piece of paper from the director, it doesn't mean the case is over. Let me know, and I will be happy to share with you all of that material. Okay, what are the claims that you're going to bring? So most of the cases we deal with are going to be Eighth Amendment claims about conditions conditions in the prisons, which includes a broad variety of things. So conditions means, again, as I was saying before, pretty much anything that happens inside prison. So it can include denial of medical care, it can include denial of mental health care, it can include physical conditions like the cell was dirty. So it includes a wide variety of things that don't sound like conditions themselves, but they're all under the Eighth Amendment. Sexual assault is under the Eighth Amendment as well. The 14th Amendment comes in. The Eighth Amendment does not apply to people who are in jails. So the same sorts of claims that we bring under the Eighth Amendment for prisoners are brought under the 14th Amendment due process clause for jails. The reason it doesn't apply is because the Eighth Amendment has to do with punishments, and you can't punish people at all that are in jail pending their trials because they haven't been convicted of anything yet. So it's a due process claim there. Also, the 14th Amendment has been used for due process in a more procedural sense in the prisons themselves. So if somebody doesn't get a hearing that complies with some very basic rules of due process, that can be a claim. And also, there's occasionally have been equal protection claims brought. That is, that some group of prisoners was treated differently than others. Usually, those are racial discrimination claims, but not necessarily. There have been some so-called class of one cases where somebody says they are being singled out for some reason for particular harm. So sometimes the 14th Amendment's equal protection clause comes into play in the prison environment. The First Amendment is something else you may bring, and that can include censorship. Happens all the time in prisons. It can include retaliation, and that is somebody files a grievance and all of a sudden they're written up for a disciplinary report that's bogus in retaliation for filing a grievance. And freedom of religion. Welcome back, Nikki. Occasionally, the 14th Amendment comes into play. In general, prisons have no right of privacy in their cells, and therefore the Fourth Amendment does not come into play. Very recently, there's been a little bit of an expansion on that, so that the Fourth Amendment is back in play. I would say for decades, there were no Fourth Amendment cases at all, but very recently, in a case which we circulated, whose name I'm blocking on. What's the name of the Logan case? Nikki, do you remember that? Class action case? Okay. It was in the materials we circulated.
I just call it the Logan case.
Yeah, it's the Logan strip search case, where dozens of female prisoners were strip searched as part of a training exercise in front of lots of other guards in a very public sort of way, in a very humiliating sort of way. And en banc, the Seventh Circuit said that is a Fourth Amendment violation against unreasonable searches. But there will be very few of those claims. In general, the Fourth Amendment just doesn't apply in prisons because you have no right of privacy in your cell. They can search it for any reason or no reason at all, or just because they don't like you, and you're not going to get a Fourth Amendment claim out of that. We did talk about statutory claims a little bit earlier. The ADA is, I think, the biggest one. The parallel federal statute is the Rehabilitation Act, RA. It has the exact same coverage as the ADA, has slightly different rules as to who it applies to, and whether you can get damages. So often people will plead both those in parallel. And then sometimes you can be creative, like we have a Clean Water Act claim that we've brought. So because water is terrible in prisons, as I indicated earlier. So don't discount statutory claims. They may well be easier to prove than some of the constitutional claims, which have really high bars of evidence. And some of the statutory claims are going to be easier, and prisoners generally aren't going to know about that. So try to be creative. And then there are common law claims. And there was an earlier question about whether or not you might be able to bring a medical malpractice claim instead of or in addition to an Eighth Amendment claim about medical care. Yes, you can. Think about whether you want to or not. On the one hand, the standard is lower, so it's easier to prove. On the other hand, there are some procedural hurdles you have to go through in order to bring a medical malpractice claim. We'll talk a lot more about those in this afternoon. And then the other question is whether or not you want to confuse the jury by making them rule on two different things. And the final thing is, just to keep in the back of your head, is if you win on one of these common law claims, you don't get attorney's fees, whereas you would if you win on one of the federal constitutional claims. So do you want to do that or not? It's a judgment call. Just be aware that they are there as a possibility.
I will note also for the state claims, there is potentially the ability to do a respondeat superior claim that you don't have in some of these federal claims against the medical care providers and their employers. So just something to keep in mind that is a little bit unclear on this on the statute right now, but there is case law out there that would support that, and then the ability to get punitive damages on those claims too.
All right, so those are the basic elements. We'll talk about the details of some of those claims in a minute, but we want to talk first about who do you sue. And often prisoners will sue people that are not appropriate. Now, again, most of this is going to be screened out by the court, but you still should understand it because a prisoner may ask you, say, hey, you know, I sued the state of Illinois, I sued the Illinois Department of Corrections because they're the ones that screwed up, not some individual guard. It's the whole department that's at fault, and the judge dismissed it. So why is that? Well, they made a mistake. I want to sue the Department of Corrections. So you should know why that's not appropriate defense. So usually not appropriate defense. The state of Illinois cannot be sued as a defendant in a Section 1983 case. Why? Because the Supreme Court has said that 1983, which is the statutory vehicle that gives you a private cause of action, that states are not persons under the 1983, and therefore there is no cause of action against them. Also, there's the 11th Amendment, which provides immunity to states for being sued in federal court. So in general, the state of Illinois is not going to be a proper defendant. The Illinois Department of Corrections is similarly not a proper defendant. Why is that? Again, because they aren't really a legal entity at all. They're just in a branch of the state of Illinois. And for the same reason you can't sue the state of Illinois, you can't sue the Illinois Department of Corrections. One big exception there, for those of you who have a disability case, is the Americans with Disability Act, which specifically does say that there's a cause of action against the entity which receives federal funding, which is what triggers liability under the ADA. And the Illinois Department of Corrections in every prison system and every county jail in the state does get federal money. And therefore, the Illinois Department of Corrections is an appropriate defendant in an ADA claim. Stateville Correctional Center, or now Stateville is closed, but Menard Correctional Center. Again, people say, you know, why should I sue an individual person? This whole place is the problem. You know, Menard is falling apart. And that's my real claim, is Menard just is terrible and should be closed. Well, as one Seventh Circuit judge put it, Stateville is a building. Buildings can't violate the Constitution. Only people can violate the Constitution. So you can't sue the Stateville Correctional Center or any other prison as a prison. You can't sue buildings. You have to sue people. The director of the Illinois Department of Corrections, again, unlikely to be personally involved. And this is a point where I have to emphasize there is no respondeat superior under Section 1983 or in these constitutional claims in general. You have to prove that the people you are suing are the ones that caused the harm. not just that they were generally in charge of the department and therefore should be responsible. So unless you have direct participation by the director of the Illinois Department of Corrections for a damages case, you shouldn't be suing them. Despite the fact that they may have signed off on a grievance, it doesn't matter. The Seventh Circuit, again, has been very clear that the person who caused the problem is the one that gets sued, not the one that failed to remedy it, which is also why you can't sue grievance officers in general. And I cited the case here, Burks versus Ramish. Again, the Seventh Circuit has said grievance officers are supposed to be investigating and fixing problems. They're not the ones that cause the problem. You should sue the people who caused the problem, not the people who failed to fix it. Now, all of this is a little bit different if you're seeking injunctive relief. That is, you're asking them to fix a problem going forward. So, for example, you may have a prisoner who has not gotten medical care. You want to sue them for damages, but you also want to get them medical care. In which case, the director of the Illinois Department of Corrections, in their official capacity, and we'll talk a minute about what that means, is the appropriate defendant. You're not saying that they did anything wrong personally. You're just saying that they're the ones who can provide relief to my client. And that's important because if you were just to sue, for example, the doctor that provided care, then by the time this case gets to trial and you win the injunction, the doctor may well not be there, or the prisoner may have been transferred to a different prison, at which point the doctors are going to say, I have no power to do anything at this point. My work is at Menard. He's now at Pontiac. What am I supposed to do? So that's why suing the director of the Department of Corrections in their official capacity is the right way to go for injunctive relief, because they're the persons that can fix the problem. Similarly, Cook County Jail is a building. You can't sue them. The sheriff of Cook County stands in the same position as the director of the Illinois Department of Corrections. They are unlikely to be personally involved. There is an exception here, which does not apply in the state, which is what's commonly known as a Monell claim. That is, if you say there is a policy or practice that is officially adopted by the sheriff of Cook County that is the one that caused your client harm, then they are an appropriate defendant. You can't do that for the state because, as I said, the state itself cannot be sued in federal court and they're immune. So there's no such thing as a Monell claim against the state of Illinois, but there is against the sheriff of Cook County. The county itself generally can't be sued for the damages or injunctive relief. Illinois has this weird system where the county has no ability to order the sheriff to do anything. Sheriff is an independently elected constitutional officer and therefore doesn't have to listen to Cook County as to how the jail is run. However, the sheriff has no taxing ability and therefore they have no ability to pay for things. So the way that sort of works out in your practice is if you're suing a county, you can add the sheriff of Cook County or something that happened in Cook County Jail, then you may want to add Cook County solely for the purpose of indemnification. You don't want to get $1 million judgment against the sheriff of Cook County and then say, hey, I don't know, I don't got $1 million. I have no way to raise it. And it's the county that has to pay for it. And the county says, we're not parties to this case. We have nothing to do with this case. You can't ask us to pay this money. So you can name them in I've given you the Seventh Circuit case that allows you to do this. You can name the county which runs the jail for indemnification purposes only. Again, you're not saying they did anything wrong. You're just saying, hey, if the sheriff ends up doing it, then you get it. Okay. So I mentioned here briefly official versus individual capacity. In the state system, it's really simple. If you're asking for an injunction, you're suing them in an official capacity. That is, you're suing that office. Why? Because when you get an injunction, you don't care who sits in that seat. Whoever's sitting there at the time, they're the ones you want to be ordered to do something to fix the problem. So you want to sue the warden in his or her official capacity. When it comes to damages, though, you're suing them in their individual capacity. Again, you're not suing the office because if you get to trial and some new warden has come in and you're suing the old warden, the new warden's going to say, hey, I didn't do anything wrong. You can't sue me for damages. You got to go after the old warden. So you're suing for damages the individual. For injunctive relief, you're suing in the official capacity. As I said, it's a little bit different for the county because you can sue in official capacity for a Monell claim. That is, you're not saying the sheriff themselves is the one who screwed up. You're saying the office of the sheriff has this policy or procedure that is what caused your client some harm. And I think this is a good time. Sorry you just got back, Nikki, but I think this is a good time for a 5-minute break. Let's take 5 minutes. You can all stretch, get something to drink, and we will come back again. And we will be talking about the sorts of documents you might figure out who you're suing and what you can look at. So we will be back at 11:07. All right, we are back in business. Before we turn to discovery, I want to emphasize one other thing, which is the physical injury requirement. Something we've dealt with a lot. This is the second provision of the Prison Litigation Reform Act, which we're going to talk about. 42 SC 1997 EE, two E's in a row at the end there, bars recovery of mental or emotional injury without a physical injury. So you can't do pain and suffering without a physical injury. Now, the courts have made it clear that you don't have to have like a bone sticking out or anything like that as a physical injury, but there does have to be some physical injury. That can be a serious concern in things like a freedom of religion case. If somebody is denied, for example, the right to have a Bible, how do you prove a physical injury for that? There's likely not to be one. And that means you can't get any compensatory damages. But it does not bar injunctive relief, and it does not bar punitive damages. So you can still get those sorts of damages, but you can't get emotional distress. We've dealt with several cases which have narrow questions as to whether or not there's a physical injury. This is particularly tricky in some of the mental health cases that we've brought, where somebody does not, may be suffering from severe depression. They sit in their cell all curled up and feel horrific, but it is really a mental problem. It is not a physical injury. So do they get any compensation? Well, you have to be creative and think carefully about, are there in fact some physical injuries there? So for example, and we have one case where a prisoner, as part of his severe depression and mental illness, cut himself. And the circuit said, well, it's a self-inflicted harm, but there's clearly physical harm going on there, and therefore that's sufficient. Nikki, can you think of the other sorts of creative physical injury things we've dealt with? And how does it, also relatedly, since you just filed these, how does this apply in sexual assault cases?
That's an easier question. So under the case law, the name that is totally blanking on me right now, any sexual assault is considered an automatic physical injury. So any kind of penetrative sex act is a physical injury. You don't have to go further than that, which is great, because going into the details of what is an injury in that kind of circumstance is, quite frankly, gross. As far as other creative physical injuries we've had in the past, one of the ones is, the failure to exercise, especially when you're talking about housing conditions and out of cell time and solitary confinement, segregation, so that it's hard to capture a physical injury by sitting still, but a failure to be able to exercise and then a deterioration of the human body because of that is kind of one of the ways around that, and that has been upheld in the case law. So that's kind of one of those that maybe we don't think about because it's not a cut or a bruise or something like that. But that's an option.
And also, like, for example, when Stateville was open, being sent to solitary there, one of the terrible things about solitary was that it was infested by roaches. So people might get a roach bite. It's obviously not the main thing that they're complaining about when they're in solitary is a roach bite, but nonetheless, it is a physical injury. And once you have any physical injury, it opens the gates to all mental and emotional injury. So it doesn't have to be a pain and suffering caused by the roach bite. If you have the roach bite, then you can talk about everything that happened while you're in solitary, even if there weren't separate physical injuries for other sorts of things. So it's not a causation requirement, it's a gatekeeping requirement. So this is why I say it really requires some very careful discussion with your client as to exactly what went on with his life and what sorts of injuries he actually experienced, whether or not they're the key to your case or not. And again, it's not grounds for dismissal no matter what. It's only a limitation on the sorts of recovery you can get. It is never grounds to dismiss a case. Okay, let's talk a little bit about the sorts of documents you're going to be able to find during discovery. In part, this is helpful to, at the very beginning, to identify whether or not I have the right defendants, but it's also relevant to the substance of the case, substance claims you have. So the first thing we talked before about grievances, but I want to talk about the other sorts of paper that in a lot of these cases are disciplinary reports. Unfortunately, these are all handwritten, still in the Department of Corrections. There's very few disciplinary reports are typed out, although there's some. we will often see in like an excessive use of force case, for example, if your client says I got beat up by guards, it's very typical that the guards will have written disciplinary reports saying the prisoners swung first, and therefore they're the ones that actually violated the rules. I don't think I've ever done a use of force case where the prisoner was not also charged with some sort of disciplinary violation at the same time. Again, this is important because it will certainly tell you the guard's version of what happened. So it's a good way to find out in advance of doing any discovery at all as to what the guards are going to say happened. It will also help identify people. Obviously, if they wrote a disciplinary report, they were there. And it may list some other people who were there. So that is a good source not only to identify what happened, but also to identify potential witnesses. When after a disciplinary report is filed, then there is a hearing before an adjustment committee, and they will again list not only who often listen who was there in a more easily readable format. So as you can see from the one on the screen here, it clearly identified that Sergeant Houston had some role here in this. So again, it's another version of what happened and who was involved. And it also lists the particular officer who was involved in the incident as well on this particular form. So that would give you two people who are potentially defendants here, their names. Prisoner may not know the names of everybody who was involved. They see an awful lot of people and they may not know everybody who was involved in something. I did talk about grievances before. So grievances are useful, obviously, because you have to exhaust your administrative remedies, but it's also something that your client filled out much closer to the time of the incident and may have remembered names at the time that they don't remember now. And it's also important because that's what the defendants are going to use to cross-examine your client with. If the facts as they develop during the case differ significantly from what they put in the grievance, then you're going to have a problem because this is, again, what he wrote before he talked to a lawyer and before there was any case and right at the time it happened. So again, the grievance is an important piece of paper to have. Both the disciplinary reports and the grievances and the administrative review board decision should all be something that the prisoner has. Similarly here, this is the counselor's response to the grievance. Often the response, remember this goes to a counselor and the counselor may not know the answer. So often the counselor is going to call up somebody and say, hey, what happened here? In this particular case, exactly that happened. The counselor called up Chaplain Miller, who was the one who was denying our client the special religious diet he wanted. So now we know not only his name, but his title and the way he spells his name. And that's all there in response to the grievance. That'll often happen in medical care cases as well. The counselor will not know anything about medical care, will call up the medical provider and say, hey, what happened? And the response will be, Dr. So-and-so said everything was great. Well, everything's great, not helpful, but the fact that you now know the name of the doctor can be extremely important. So don't think of grievances as just providing evidence that they exhausted administrative remedies, but also as a source of information. Same thing here on responses. This is the grievance officer's response to a grievance. So this is the second step in the process. And again, here you get a response from Dr. Renzi. So again, you know who the Dr. Renzi was involved in some way. She's giving her version of things, but also identifying other people who are involved in her response. So you have an MHP Duckworth, an MHP Hardy, MHP Renzi and Nelson. So here you got a whole bunch of people who are involved in the care for this particular client, as set forth in the response to the grievance. In some cases, there will also be incident reports filled out. So in general, any employee of the Department of Corrections who sees something out of ordinary that happens are supposed to fill out an incident report. Now, that does not apply to medical personnel. So doctors and nurses do not have to fill out incident reports about things that happen on the medical side, but they do have something that happened in the medical unit. So, for example, this is an incident report filled out by a nurse who was working in the healthcare unit and viewed a attack on our client in the healthcare unit. So she filled out an incident report listing, in this case, the other people who were present, including the people who were involved in the actual use of force, defendants Hassemeyer and Pickering. So from those incident reports, you can often find out things that were happening and who was involved in it. Now, this is something the prisoner does not get copies of, so you're going to have to get this one through discovery. Incident reports are not provided to the prisoners. Occasionally, you will find something that goes beyond an incident report, an actual investigation done by Internal Affairs. Internal Affairs is sort of the internal police department at the Department of Corrections. They're responsible for reviewing and investigating serious misconduct, both by guards and by prisoners, which means they have a real conflict of interest, in my personal opinion, since they're investigating both parties in a dispute, and therefore sometimes they're pro prison guard and sometimes they're supposed to be investigating those exact same prison guards. But nonetheless, if you have a case where there was an internal affairs investigation done, it can be a key piece of evidence for you and save you a tremendous amount of time. What I've given you here is just a summary, but normally these would be a maybe 50 to 100 page report, which would include interviews with everybody who was involved in any way, both prisoners and guards or other department employees. It won't be a verbatim statement of what they said. It's not like they have a court reporter there, but I found they do pretty good summaries of what the people said. It will also include copies of grievances, copies of medical records, copies of disciplinary reports, as well as sometimes even photographs of what happened or of your client after the injuries. So if it happened, then if there is such a investigation in your case, then it's absolutely important that you have a copy of that investigative report. Again, this is something your prisoner will not have. You have to get it through discovery. It's also important to remember that some of these investigations are done in-house, that is, by Internal Affairs at the prison where the thing happened. Sometimes they're dealt with out of Springfield, and you may have to serve a separate subpoena on the Department of Corrections in Springfield in order to get the Springfield-based ones as compared to the ones that are kept at the prison itself. Anything you want to add, Nikki, about Internal Affairs reports? This particular one lists the 20 different people that they interviewed, for example. So they did a whole lot of work for you of figuring out who was involved and what they had to say about it. This will give you a great roadmap as to who you want to depose, or some people you may not have to depose at all to save yourself some money. If they give a statement that either shows that they were sort of marginally involved or is so detailed that you feel that you don't have to take a deposition, that they're just going to say the same thing, then you might be able to skip that one and save yourself some time and money about taking a deposition. So this is a great place to start your investigation if there in fact exists. Medical records are a mess in the Department of Corrections, but nonetheless really important, both to identify your appropriate defendants if in fact you have a medical-based claim, and also to figure out what kind of documentation you have of injuries. For example, if somebody gets beat up, what kind of medical care did they get? You may also want it for purposes of figuring out whether or not your client had a pre-existing condition. So getting their medical records is really important. Unfortunately, despite the fact that for maybe 15 years, the department has had a program to convert all of their records to electronic medical records, it hasn't done so yet. With two exceptions, the two women's prisons, Logan and what's the second? I'm blocking on the second.
Decatur.
Decatur, right? Logan and Decatur have electronic records and have had so forever. I won't say that they're all that easy to read because they're not very well organized, but at least they're legible. This particular one is very legible. It is an exception, but in general, you're going to be dealing with a lot of handwritten records. Again, they're useful obviously for the substance of the case, but also to identify which doctors, which nurses, which other medical personnel dealt with your client, and therefore who the appropriate defendants might be. We'll talk a lot more about medical records this afternoon when we have our medical case. Other parts of the prison are, I have to say, still trying to figure out technology as well. Some parts of the prison are highly computerized, other parts not so much. This is an old one, but frankly, I've seen them more recently. Sometimes particularly in segregation units, there is a book that looks exactly like this, the same kind of book you used in second grade, which is used to sign in and out of the unit. So, some places are all nicely computerized, other places still have these books. I'll never forget going to Pontiac's, and there was a guy sitting in a wire cage with a long pole. He would put this book on the end of the pole and put it through the cage, and you have to take the book and sign into it, and then you put it back on the pole and bring it back into the cage, as low tech as you can get. But whatever form it is, these sort of logs can be really important. In this particular case, for example, this is a guy who got allegedly beat up in the showers at I think it was Menard Correctional Center. And I said earlier that often the directors and wardens are not personally involved. In this particular case, the client said, "Oh no, they were right there. They watched the whole thing and just watched me get beat the crap out of and didn't say a word." Well, this sign-in book actually became crucial evidence here, because you see that it says at the bottom here, the second last entry, Director Neal, who was the director at that time of the Southern District of Illinois, had signed into the unit. Now, does that prove that he was there in the shower? No, but it's certainly good circumstantial evidence to support that he was there. He was in the unit at the time. And that plus your client saying, yeah, he was right there and I saw him, is pretty good evidence that in fact he was there. And right above his name is the warden. Warden Cowan was also there at the exact same time as Director Neal was. They happened to be touring unit when all this happened. So this could be a crucial piece of evidence to support your client's claim that in fact those wardens and directors aren't just supervisory officials sitting out in Springfield somewhere, but were physically there on the day and time that this happened. Excuse me.
While Alan popped out, I'm gonna chime in on a couple other pieces of documents that you might want to be getting for these cases. One thing that I found really useful is what's called the cumulative counseling summary, or else it's called CHAMPS, CHAMPS, and that keeps track of all the places, all the contacts our clients have had with their counselors. Who are the people that kind of organize programming and all those kinds of things. So it can show you where your client was at and what they were doing and who's speaking to them. Another really useful thing is people's housing placements. There's a whole housing history and program history that shows where your client was, when, and for what period. And that can be really helpful in just like getting your timeline down. What units they were at, all these kinds of things to help with that. So for a lot of these things, you don't need to go through discovery. You can get them through a master file request, which as long as your client is still in custody, it's a fairly easy way to get documents. That's also a way you can get a limited amount of grievances and disciplinary reports, without having to go through the official discovery process, which can be slow. Usually these requests, you can get them back in a week or two. So it's a good, quick way to do some initial investigation without having to go through the discovery process.
I will say, I completely agree. I will say that you shouldn't, particularly the CHAMPS, but also things like attendance logs and assignment logs. They're all nicely computerized, but that doesn't mean they're accurate. Counselors will often admit that no, not all the contacts with prisoners get logged into my electronic file. And again, a sexual assault case we did many years ago, when I got the computer printout of what people's assignments were, showed that the person who my client said raped her was assigned to perimeter duty. That is, their job was to go in the van and drive around the outside of the prison in order to make sure nobody's escaping, basically. And he says, I never set foot in the prison. I couldn't possibly rape her. And that's in fact what the computerized log showed. But our client insisted that she was right. That was actually the guy, and we continued to get more and more documents. And eventually it turned over a copy of that computerized list of assignments with some handwritten notes on it. And the handwritten notes showed that he was lunchtime relief, which in this particular case, because it was third shift, meant midnight, that he was lunchtime relief for the person who was assigned to the unit that she said she was raped on. So in fact, ultimately, while the computer printout showed that he was exactly right, that he did the outside perimeter, once we found out that the computer didn't show everything, in fact, the handwritten corrections to the computer showed that he was exactly where our client said he was, in which point the case settled. So Don't trust the computerized stuff. It's a good start, but like many IDOC records, they are not complete. And you have to keep in mind, these are created for the department's use. Their point is not to support prisoners' claims of misconduct. So, you know, it's a good starting place. It's a great admission if you can find stuff that helps you. But if it's not there, don't assume that your client is lying. All kinds of stuff can be missing from these things. The final thing, which is really growing tremendously important, is electronically stored information, ESI. This is an example of one thing that was found in discovery in one of our cases. This was our medical class action case. We were trying to show that they were vastly understaffed, and there was a communication from the central office down to the head of the healthcare unit in the particular prison, asking how is your caseload, and for whatever reason they decided that rather than typing out a response, they should answer with emojis. And obviously this is quite important piece of evidence here that they were fully aware that they would have a problem. Where this come out as to just how badly off they were. Similarly, we had in a different prison, same sort of communication about our particular client in this case, and the response came back saying, "Oh, if the Lippert, that is our class action case lawyers, ever found out about this, we'd be in big trouble." And that was produced in discovery as a piece of email. So I will say it's not easy to get email from the Department of Corrections. They are loath to do these searches. I think the attorney generals are becoming better and better at figuring out how ESI should work. But it is burdensome. They don't have the same sort of access to many of the electronic platforms that people in private practice use day in, day out, like Relativity or other similar platforms. Generally are not available to the attorney general's office. Therefore, it's a pain in the neck for them to do ESI discovery, and they will try to limit you as much as they can get away with. Like any case, I think going back and forth about exactly what the parameters of ESI should be is part of discovery in every case, but don't ignore it in the Department of Corrections, and don't assume that there isn't any just because they don't tend to use it very much. I think that often people who work at the Department of Corrections have not figured out that what they write down in emails can be used against them, and therefore there's often great admissions that are made in these email communications, which are very helpful to you. So make sure you get it. I want to briefly talk about the statute of limitations here. Generally, it's 2 years statute of limitations, and there's virtually no relation back. It's really hard to bring in somebody past the time. We were able to do it in one case where we had misnamed the person, and they had served. We had only had the last name of a person. They had served the person's wife, who had that last name, who was also an employee of the Department of Corrections, and we were able to convince the judge that, in fact, it was just a misnomer, and that the husband was the appropriate defendant, and he clearly had notice of it because his wife had been served, and they perfectly well know between the two of them that it was the right person. So we're able to get the judge to agree that you could bring in the husband, even though we hadn't named them appropriately within the statute of limitations. But don't count on that. It's extremely rare that relation back will work. Two things, though, that do help you out here. One is the mailbox rule. That is, because prisoners can't walk into the court and file things on their own, and certainly can't electronically file things on their own, they're dependent on prison officials to do the filing, and therefore what's commonly known as the mailbox rule applies. That is, when the complaint is handed over to prison officials for filing is the date that it's deemed filed by the court. So this can be important if you're within a couple of days of the statute of limitations as to the exact filing date. The other thing that's really important here is that during the pendency of any grievances, the statute of limitations is told. That is, it doesn't start running until the grievance process is exhausted. So again, don't assume that just because it's past 2 years from when this happened, that you're necessarily out of the box from adding appropriate defendants. It's very important to figure out exactly how long has the grievance has been pending. Nikki, I think you started talking about this before, but why would you or would you not bring a medical malpractice claim in addition to your 8th Amendment medical claim?
Yeah, so I think the one thing is that, if your Eighth Amendment claims get dismissed, you might end up back in state court, which is unfortunate for everyone. But that's one of the biggest downfalls I think on it. And as Alan mentioned, like the confusion that you might get to the jury for the different standards. But with that, you have a lower standard. You don't have to prove deliberate indifference for a medical malpractice case. Um, I think one of the other downfalls, and it's a little unclear, is what you have to do to get the complaint into court with that. Traditional medical malpractice claims require that you submit an affidavit from a medical provider saying that there was a problem here with your complaint. There is some case law out there that for prisoner cases, we don't have to do that as long as we get it done by summary judgment. Um, we've won and lost that claim. So that's it's a little bit of an iffy situation. But with that, you have to then have an expert at some point in your medical case. I think most medical cases you want an expert, but if you do a medical malpractice claim, you have to have an expert in it.
And how about a tort claim like battery or wrongful death or anything like that?
Yeah, so for a tort claim, again, it's you have a lower standard. I think you don't need a necessarily a if it's a straight up battery claim, you don't necessarily need an affidavit. If it's a medical battery claim, you do need your affidavit still. The one thing that we found in doing some research on these claims is that you can, against a medical provider, so against Centurion, who is now the medical provider at the private corporation who provides medical care in IDOC, you can do respondeat superior claims against the employer just for employing the person who was negligent in the scope of their employment, which is something you don't get in a constitutional claim. And because of that, you may get punitive damages against the employer, which you also can't get. So there's a little hook there. It is a deeply, deeply hidden Seventh Circuit case law. The judge that we presented it to, her eyes were like, "What? I can't believe this is happening." And we're like, "We can't either, but it's the case law." So there is that loophole there. We didn't actually get anything on that claim, but it's out there. It's a potential. So it's something worth at least investigating and figuring out. The other state law claim that we've been using recently is the Illinois Gender Violence Act, which the bonuses of that is that it has a longer statute of limitations. I think it's 5 years. So you have more time to file these cases, especially I think for sexual assault, where sometimes things come out a little bit later in time. And often grievances aren't filed that toll. So that's another hook to get some of these sexual assault perpetrators into court. If you have a statute of limitations problem. And
Yes,
also with state claims, you don't necessarily have to file a grievance. Depending on your claims, you may not have to exhaust because the PLRA specifically talks about federal claims. So that could be a way to get around the grievances process, but I would be very careful and read your statute very carefully about what is required as far as exhaustion of remedies.
and of course, if you haven't exhausted, then you may end up getting kicked to state court. If all you have left are state court claims, you're going to end up in state court.
Exactly.
And by the way, if you're appointed to a case and it ends up getting kicked off to state court, you are not required to continue to do that in state court. Your appointment is by the federal court to do the federal court case. If the federal court case is dismissed for whatever reason, you're not required to follow it up and file something separate in state court. You're not required to do an appeal should you lose. Your appointment is for the case in the district court, period. Nikki, somebody raised a question earlier on. What if the suit is about living conditions? The cell is terrible. Who's responsible? You can't sue the prison.
My
Who do you
point of view has always been it's the warden who is in charge of the whole prison, or the cell house sergeant or major, someone who has authority to make some changes at the facility, and so then they're the ones responsible for ensuring that the cells have decent living conditions. I mean, you could possibly maybe go up to the director as in their individual capacity, because they are in charge of the whole system. They have the ultimate responsibility that all of the prisons are livable. And so, I mean, it's maybe a hard hill to get up to prove this knowledge, but it could be possible.
Yeah, so a similar sort of case where we did sue the director, sorry, the governor actually, We had a case on behalf of a very mentally ill woman who should have been inpatient. No question, she required inpatient care. And at that point, Illinois had no facilities providing inpatient care for somebody. So we actually sued the governor, saying that he was aware of the fact that they did not have an inpatient facility, and therefore the governor was responsible for it. He's the only one who could have said, yes, let's build a new prison or a new facility or made an arrangement or something along those lines. So even as high as the governor, we did sue him. The case settled, so I can't tell you whether or not.
Oh no,
well,
it's
still
that one's
pending.
pending on summary
Still
judgment.
pending, right? Still pending
We
on
will
summary
see.
judgment. So we will see whether or not our claim survived. But we certainly had a callable claim that the governor himself was responsible in part for our clients being held in unconstitutional conditions. So again, there's not, you're right, it's difficult. It's sort of this oddity that you can't sue the state, even though they're clearly the ones that are responsible for keeping a terrible prison. But that doesn't mean it's hopeless. There are always people you can sue who had some role in forcing your client to be there under those conditions. And the rule is not that that the governor or the warden had to know about your particular client's injury. They just had to know about the fact that there was unconstitutional conditions that occurred in their prison, and that somebody would be assigned to it. They don't have to know your particular client is the one that got assigned to it, because somebody's going to be assigned to it. So that general sort of level of knowledge is enough. Now they do have to be aware of the conditions. Okay. Okay, there's one question here about policy makers and a written policy. What if that policy changes during the course of the case? That depends on whether or not you're talking about an injunctive claim or whether or not you're talking about a damages claim. If it's just a damages claim, then any changes they make afterwards, I think, are completely irrelevant to the case, totally irrelevant to the case, and probably shouldn't even be admitted. If you're asking for injunctive relief, then there's a whole body of law about whether or not those changes are in fact sort of locked in, or whether they're temporary changes that can be undone as soon as the case is over.
I think also with the changes of policy, the one thing to really focus on with policy is it actually being implemented? If something's on paper but not actually being followed or enforced, then what is the paper's worth nothing. So I think really keeping in mind the practice side of policy is important.
Okay, we've talked about ways you can do things without doing formal discovery, but let's talk a minute about formal discovery. Clearly, all of the interrogatories and document requests and subpoenas, et cetera, that you use in any other case are available to you in prisons. There's some debate among lawyers about whether interrogatories are particularly useful. They're generally, in these sorts of situations, not filled out by the actual defendants. Rather than some lawyer or maybe the litigation coordinator at the prison actually fills them out and just gives them to the prisoner, to the actual defendant to sign. So you sort of get the party line in general. Now, sometimes that can be really useful if the guard changes their testimony at trial from what they answered in the interrogatory. That happened in a case of mine where I asked an interrogatory saying, sort of describe all of your interactions with my client that particular day. He got a very formulaic response, and then at trial put in a whole bunch of stuff about how he was deathly afraid that my client was part of a gang and he was about to be jumped, and that there were risks out there, plots that he'd heard about, that he was targeted by the gang, and that's why he had to use a lot of force right away, is in order to forestall what he thought was the beginning of a coordinated attack. None of that was mentioned in his interrogatories answers at all. So I tried to cross-examine him on that. And oddly enough, the Attorney General stood up and objected, saying that the client had actually filled those out. She had done it, and she took full responsibility for not being complete. Nonetheless, he signed them under oath. So the fact that he didn't really read them is his problem. It's a great defense, maybe. The jury was not impressed by the argument that he didn't know what he was signing. But again, you will get a pretty formulaic response. I think the same is true for request to admit. Unless it's really stuff that's non-controversial, we have found the attorney generals are very good at figuring out how to deny a request to admit without actually admitting anything. So I have not found them to be particularly useful in this sort of practice. Have you ever used them successfully, Nikki? Okay. So we generally skip those. Do be very much aware of Rule 30b-6, which allows you to take a deposition of the Department of Corrections as a legal entity. What that means is, and I'm sure many of you use this in your private practice, but it's particularly useful here. It means that in theory, they're supposed to identify a person who can then do a reasonable level of investigation to gather as much information as the department as a whole has. Now, the department tends not to do that. They tend to identify a person with the most personal knowledge and then just have them testify as to what they personally knew. That's totally inappropriate. They're supposed to do investigation. I don't know how many times I've asked people what sort of investigation they did at the beginning of these depositions, and they say none. I reviewed my incident report or my personal documents, but didn't talk to anybody about anything. And we've gotten sanctions from judges sometimes for them not doing an appropriate investigation. So I think it can be a really useful tool to use. As with any use of Rule 30b-6, a lot of the difficulties in using it are negotiating exactly what the scope of the questions will be. Rule 30b-6 makes you identify the subjects on which you'll be asking. Again, because they have a duty to investigate, it's important that they know what they're supposed to be investigating, what questions will be asked. Defendants obviously want to make those questions as narrow as possible. You want them to be as broad as possible. So that'll be a negotiation back and forth as to exactly how this will be laid out. But I have found it to be very useful. I think even if it doesn't ultimately work, it saves you a lot of time. My favorite example of that is a prisoner who got beat up by guards who he could not name, had no idea who those guards were. And we knew what time this happened. It happened in our correctional center. But who those guards were, we had no idea. So in order to figure out which guards they were, we could have, I suppose, taken 50 depositions of all the guards that were around. But instead, we did a 30b-6 deposition of the Department of Corrections, asking to identify which guard it was who was present at the time. Now, and in order to prepare for that, they assigned an internal affairs investigator, who in turn contacted every guard who was in the prison at that time and asked them whether or not they were the ones who escorted them out. Now, it turned out all of them said they were not the right one, so we didn't actually get an identified person, but we would have got the same answers had we taken 50 depositions. They all would have denied it. So this allowed us to take one 15-minute deposition instead of 50 hour-long depositions. So it saved us tremendous amounts of time to find out that we weren't going to get anywhere. Sometimes it gives you very useful information. I don't want to discount it at all. It's just a way of saving you some time. Often no particular individual will do it. So it's fine that I think it's a very valuable tool and is underutilized in these cases. Do you remember you only get one 30b-6 deposition? Just like you can't take multiple depositions of any individual defendant, you also can't take multiple depositions of a corporate defendant. So it's something you probably don't want to do at the beginning of your case. You want to make sure you have a full understanding of what kinds of questions you want to ask, and probably don't want to do it until after you've deposed some individuals to find out where the sort of gaps in knowledge are that you need to fill in with somebody doing the investigation. Nikki, anything to add as to how you use 30b-6? Okay. Take 1 minute and look at the. Okay, so I see one participant here who's where the Attorney General missed the deadline to respond to the request to admit, and the judge deemed them admitted. So I've never had that privilege of them missing the deadline, but it may be worth sending them out just in hope that they do miss the deadline, and then it's all admitted. So I would say the other side is also important. If you get requests to admit from the defendants, keep in mind it's going to take you a while to deal with your clients, so don't wait at all. I would get those out to your clients right away and start working on the answers the day you get those in, because that 30-day deadline is crucial. As was learned in that particular case, if you miss that 30-day deadline, then those facts are deemed admitted, regardless of what other proof you may have that they're false. Okay. I will say oral depositions these days tend to be mostly remote, where the court reporter is in their office, you're in your office, the defendants are in their office, and the deponent is usually in the prison, whether it's a prisoner or not. If it's my client being deposed, I insist on being there in the room with my client. I think it's absolutely important that you be there with the client and not let them sit there alone in a room, being asked questions by the Attorney General, without you being present, to sort of provide them support. It makes it much easier to talk off the record with them and consult with them during the deposition. So I strongly urge you to be there in person and not allow that deposition to go down without your being present. But in general, those remote depositions have become the rule rather than in-person depositions, which were the rule pre-COVID. As with many things, the world has changed. Anything I missed on discovery, Nikki? Okay, the other thing, I think the one thing is the right to inspect premises. If the Department of Corrections is a defendant, you can use Rule 34, which we usually use for document requests, but also allows for inspection of premises. If they're not a defendant, you can use a subpoena issued under Rule 45 to have the right to inspect the premises. I think it's invaluable. It's fascinating, frankly, to see the inside of prison. So I highly recommend you do it just for your own entertainment purposes. And not many people get to go into the bowels of a prison and see what they're actually like. So I think that's important. But I think it's also important. It allows you to put on evidence in a way that you wouldn't otherwise. I find it very difficult to have somebody describe something on the stand, which I've never seen. And it's much easier for me to ask questions of somebody, either my client or frankly cross-examine people. If I've been there, I know what the sight lines look like. I know what the cell looks like. I know what we're talking about. Similarly, during those inspections, you can have pictures taken. Back in the old days, you would usually have to hire a photographer and they would come in and take the pictures. These days, it's all digital. At least in the state prisons, you will not be allowed to bring in your own camera. Somebody who will be assigned to walk around with you with a camera, with a digital camera. They will take pictures of whatever you want. The nice thing about digital is you can look at the pictures right away and see if they captured what you meant for them to capture. You have to wait for the pictures to come back later. There will be a delay. After you take all those pictures, they will want to review them all to make sure there are no security issues that were captured in those pictures, and you'll eventually get them digitally. I will urge you to bring a second person with you who can take notes as to what pictures were taken. We've had a number of cases where some of the really bad pictures that we took somehow mysteriously disappeared between the time they were taken and the time the documents were produced to us. One of our cases was about conditions at Vienna Correctional Center, and there was a picture of a dead rat that we found sitting there in the middle of the kitchen. Mysteriously, that picture never made it out to us. If we hadn't had good notes, we would have just, they could have said, no, that picture never existed. And it's really hard to both pay attention to what they're taking pictures of and keep good notes. So I strongly urge you to bring a paralegal or somebody else with you or a second lawyer whose only job is to take notes as to every picture you've asked for. That way, when they produce them at the end, you can figure out whether or not they in fact produced all the pictures that were taken. Generally, they will want a protective order over all those pictures. And generally, judges will agree to that. I personally think that it's silly because prisoners already know what they all look like, and I don't know who they're trying to protect this information from. But they've got a whole theory about people could use those pictures to plan escapes from the outside or something along those lines. I think it's frivolous, but judges don't. So in general, those pictures will end up, a lot of those pictures anyway, will end up being marked as confidential and therefore things you cannot share. It unfortunately means that every case has to sort of go in and take pictures on their own rather than sharing. The exception to that is, and we've done quite successfully on this, if the pictures end up being part of a summary judgment motion or used at trial, then the Seventh Circuit has some quite strong case law saying anything that is the subject or was the basis of the decision has to be public. So at that point, we've often got the judge to be much more particularized as to which pictures will remain confidential, and many of them have been made non-confidential, and therefore we can share them with the public or with other lawyers who do these cases. So, be aware that you're generally going to have a confidentiality order, but make sure that there's a real reason for that confidentiality. Let's see. Yeah, somebody points out that while you can only take one 30B6 witness, they don't have to only produce one 30B6 deposition. Often they will produce multiple witnesses for different topics in 30B6, and you get the full 7 hours with each witness that they identify. So your depositions can look like multiple depositions because basically they don't have to be in the same day. You can do them on different days. So you can do that. Let's see. I don't know, Nikki, is there anything else in the chat that I've missed that I haven't answered? I think most of this stuff has been answered.
Yeah, I think it's most of it we've talked about are in the materials already.
Okay. I want to briefly talk about.
You haven't changed the slide though yet. You might want to get to the more interesting ones.
There's not much more. We're almost at the end. And this is just demonstrative evidence. I think it's really important to get in there, take those pictures. Jurors haven't seen the inside of prison, so it's one way to make sure they stay focused during the case is to have pictures that they can look at. Also, for things like cells, they're likely to think about what's on TV. Actual cells often don't look like what's on TV. If you're talking about union, like a medical case where somebody has to sit in a waiting room for an hour waiting to see the doctor, a typical juror is going to think about their own doctor's waiting room. That's not so bad. But in fact, in most prisons, you're sitting in a tiny little room, which is actually a cage. You're handcuffed with maybe 30 other people waiting. Many prisoners have told us it's one of the most dangerous places to be, sitting there in the medical. If, for example, you have a beef with a particular gang, this is a time they may have access to you in a way they would not normally on the cells. So again, pictures of that waiting room might be important just in a medical case. It may not be crucial, but again, it just sets the stage for a juror to understand what your client is going through. Exam rooms are often in terrible conditions. They're based, in some cases, they're just cells that have been converted into an exam room. So again, a juror may think about their own doctor's exam rooms, which are usually nice and clean and well appointed and have all the equipment there and all that kind of stuff. If you get a picture of a typical exam room in a prison, they won't look much like they do in your own doctor's offices. So even for cases which don't really relate to conditions, be creative and figure out how you can, actually show what a cell looks like. This particular one in Stateville gives you an idea of just how huge and crowded some of these prisons can be. Where you have stacks and stacks of people all with open bars. These can be very loud units, for example. They're obviously very dehumanizing. So again, somebody may not have a good idea unless they have a picture or can see it in person. This is a cell I think this is a solitary cell at Menard. I think that's what this is. And again, it's a tiny little cell. People don't have a good idea of just how small those cells are unless they have a chance to actually see them in person. This is a segregation unit at Menard. Again, tiny little cells, old rusted beds, as you can see. You can also see the toilet is like 3 inches away from the person who's sleeping there. Not a pleasant place to be. It also, on the left here, is the outside of that cell, where you can see that there are solid front doors. This particular one is interesting. The little orange lock you can kind of see here is not the IDOC security lock. That is a crime scene lock, because one of those prisoners murdered the other one inside the cell, and it became a crime scene. So being locked in solitary can have its own drawbacks, which again, people may not recognize without actually seeing what this looks like from the inside. This is a crisis cell at Pontiac. One of the brand new, this is a brand new cell, completely reconfigured at Pontiac. It still looks pretty horrible. You can see on the back here that the toilet is just a hole in a concrete ledge here. And the sink is the same thing, part of a big concrete ledge here. And it's just a bare, barren cell. They painted them blue in order to try to calm people down. That's the idea, is they're supposed to be nicer cells than some of the other ones, which were painted off-white. But they're still pretty horrible places to be. And people, again, may not think about this as where you put someone who's suicidal. I think it's a fair question is, is this actually going to calm anybody down who's otherwise suicidal. I would say looking at the picture is really useful to get a good idea of just what it's like to be there. I want to talk briefly about settlement here. I think it's something you want to keep in mind from the beginning. I think it's important. Many times when you're first appointed, the Attorney General will come to you and say, "Hey, this case is totally worth this, but we'll give you a couple $1,000s in order to make this case go away." Don't settle too early is my warning here. Until you figure out how bad is the injury, is there a permanency to this injury, how good is the liability, how does your client come across, how does the defendant come across, you really don't have a good basis for valuing the case. So, you know, the attorney generals have good access to what other cases are paying, but they don't have to tell you that, obviously. We at the Uptown People's Law Center are in the process of trying to put together a good database of all the settlements and verdicts that have been issued against the Department of Corrections. We have that available now as to Wexford, although it's not quite up to date anymore. It's like 3 years old. But as to all the medical claims against Wexford, we have a pretty good database, which we are happy to share with you if you ask us for it. So I think my point here is think about settlement from the beginning, but don't necessarily jump into settlement negotiations right at the beginning. The numbers are unlikely to get worse than what the Attorney General's office is early, and are very likely to go up once you all have a good idea of the actual risks that your client is taking and that they're taking. I think we said this earlier, but to be clear, it is generally not going to be the individual employee who pays. You're really negotiating with the state or the county as to how much they're going to pay. The medical providers, same thing. The company that hires them, in this case, Wexford in the past or Centurion for the present, in the Illinois Department of Corrections, and many counties have similar arrangements with private companies. Those companies are going to pay, and generally they have some sort of insurance as well. So again, you're not talking about that individual coming up with money, unless it's somebody that the Department of Corrections said we're not defending. If they're on their own, they've had to hire private counsel, then almost certainly they're not going to be reimbursed for whatever damages there are, and therefore it's crucial that you keep that in mind as you're negotiating. It doesn't do your client a whole lot of good to get $1 million verdict against somebody who you're never going to be able to collect a penny from. So do keep in mind who's defending and who's paying and what sort of pockets there are out there. So that's where that stands. You also want to watch the release. The Department of Corrections has a very broad, and Wexford have very broad releases. Sometimes they require you to release all claims you might have against the department or against Wexford. You generally want to be careful not to do that. Your client may have 5 or 6 different claims pending, and you don't want to accidentally settle all of those cases. Now, maybe the defendants do want to settle all those cases, and you can negotiate a settlement, a global settlement for all of his pending cases, but you want to be very clear with your client that's what you're doing. You want to make sure you have permission from your client to do that, because you're not appointing those other cases. So be very careful of what you're waiving. Some other things to be aware of in the settlement. Often the Department of Corrections will have some liens against the claim, either for disciplinary reasons. That is, they may have, if your client caused some damage to property, for example, they may owe the state some money. You want to make sure that you have all that disclosed in advance. The worst possible scenario is that you settle for a relatively small amount of money and your client ends up getting 0 because the state had a lien against them for all of the money that they're going to get, and therefore you wouldn't get a penny. Similarly, the other thing to watch out for is child support payments. Many prisoners who go into prison, the first thing on their mind is not petitioning the judge to adjust their child support payments. They're worried about being convicted and figure out how to survive in prison. So innumerable prisoners have come out of prison only to discover that they owe thousands and thousands of dollars in back child support that they have not been paying for the last 10 years that they've been locked up. So you want to, again, the state can run that and see if there is such a lien against them. you want to make sure that you cover that in advance. The final thing is the right to right of victims of the crime to go after this money. In general, for Class X offenses, which is what most of our clients are going to be charged with, there is not a statute of limitations, and therefore they can sue at any time. And if they're registered with the state as a victim of the crime, then they automatically, by law, have to get notice of any settlement or any judgment that your client gets, and therefore they have the right to go after that money. Something that used to be true, and some people still try to use this as a bargaining thing, is the Department of Corrections used to be able to sue prisoners for the cost of their incarceration. So you used to have to get that waived. The state legislature repealed that law maybe 3 years ago now, right at the beginning of the first Pritzker administration, so about 5 years ago. But still, there, particularly at the county level, there are state attorneys who say, you know, you shouldn't bother to get more than you should accept our $5,000 offer, because anything beyond that, the state's just going to sue you and take the money back anyway. That's just not true anymore, so you should be aware of that. What else about settlement, Nikki? How do you approach settlement in these cases?
I mean, I think the first thing to approach is really get an idea of what your client wants. What are they trying to ultimately get out of this case? And listen to them and talk to them. Spend, you know, an hour just talking about what they're looking for settlement. I think one thing that I found really useful when you have a client who maybe has some unrealistic desires or thinks things are gonna get out of a settlement is to ask for a settlement conference with one of the magistrate judges. In my experience, the magistrate judges are more than happy to do these conferences, and it can help the client to realign their expectations when a judge is telling them something. There's some judges that are better at this than others. There's some judges that I would say never have a settlement conference with this person, but there's other judges that are really great. So I think that's a way to, if you think settlement is a good option for your clients, but you're just not getting there, I think having that settlement conference can be really helpful. Um, and I think, you know, just being really straightforward with your client, but ultimately making sure that they know that they are the ones making this decision. Our clients get very limited ability to make decisions, and this is the one decision that is theirs. So think just in that again, like Alan had mentioned, start off saying like having that trusting relationship with your client is going to make this process so much easier for everyone involved. So just ensuring that you're going to do what you need to do to get this case to trial if we need to, but there's a lot of pros to settlement. I think just being really forthright on that is a good idea.
Yeah, and what Nikki said there is really crucial in terms of the rules of ethics. I mean, they're allowed, I said this at the beginning, but I want to reiterate it here. Prisoners are allowed to be unreasonable in their demands. If you think the case is worth $5,000 and they think it's worth $50,000, they can say, I'm sorry, I want to gamble. I know you're telling me I'm not going to get that much, but I want to tell my story to the jury, and I want to take the risk that I may get. I know I'm not getting it. So I think the rules of ethics make it very clear they can do that. It's not grounds to withdraw from the case from representing them if the client has unreasonable goals. It just means you have to try the case. And I think that's a lesson throughout this, which is that let the court be the bearer of bad news. If you think, I mean, again, you have Rule 11 obligations. So you can't say something that's you can't file a claim that's totally frivolous. But you don't have to, tell your client this case is hopeless, you're never going to win, and therefore they should give up and dismiss it. If it's going to lose its summary judgment, let it lose its summary judgment. Let the judge be the bearer of bad news rather than you. If you can't state a cause of action, do your best. As long as you can satisfy Rule 11, put the facts in there. And if the judge ends up saying, no, this is not a claim that we can bring, then let the judge say so. This came up, for example, in a federal case we did with Bivens. We had a stretch argument, and admittedly it was a stretch argument as to whether or not his claim fell within what's left of Bivens. We made the argument that it did. The judge disagreed, and we kind of expected the judge would disagree because it was a long shot. But nonetheless, we took the long shot and let the judge deliver the bad news. So, I think that as an appointed attorney, it behooves us not to just assume we're going to lose or assume that this case is really worthless. it's the client's decision to go forward with the case and not yours. And just for client relationships, you know, you don't want to be wrong. And there's a terrible case where a lawyer said, "I'm sorry, we have the wrong defendant. You've sued the wrong defendant. The statute of limitations is over. There's nothing we can do but dismiss the case." Convinced the client that that was true, dismissed the case. The client then had second thoughts or talked to a cellmate or whatever it was, and said, no, he's wrong. Appealed to the Seventh Circuit, and the Seventh Circuit said, no, the lawyer is dead wrong. The lawyer forgot about the fact that the statute of limitations is stayed during the time of grievance is pending. You don't want a Seventh Circuit opinion saying you don't know how to calculate a statute of limitations. So again, it's an affirmative defense. There's no reason to dismiss. Let the defendants raise it to the judge, and make the judge deliver the bad news. There's no upside to your voluntarily getting rid of a case, which again satisfies the Rule 11 situation. On the same track here, I want to note that most of the judges who appoint lawyers, when they ask you to file an amended complaint, which many of the appointment letters do, particularly in the Northern District, they all say consistent with your Rule 11 obligations. And judges have explained to me that they put that in there not as a threat against the lawyers, but rather as a tool the lawyers can use with the client. Saying here, it says right here in my appointment letter that I can't bring a frivolous claim. So it's a tool you can use to persuade your client that there's some claims you just can't bring, even though they think they're completely valid. Again, like suing the director. They may say, he's the one who's responsible. The whole system is screwed up, and you got to sue the director because they're the ones who should have known about this and they should have done something about it. Well, the case law is really clear that should have known is not good enough. You have to have actual knowledge and actually decided not to fix the problem. And you're just not going to get that with a director in 99% of the cases. So you can explain to a client in the appropriate case, and I emphasize the appropriate case, that you just can't do this consistent with the rules of civil procedure, that there are limits on your duty to zealously advocate for your client. But you do have a duty to zealously advocate for your client. So always keep in mind that balance. And that's why developing a good working relationship with your client is so important. And I emphasize again, doing that at the outside of the case, where everybody's good and on the same page, fantastic. That's the time you want to build that trust. You want to build that relationship so that everybody understands what's going on from the very beginning, and you begin to communicate. Your client understands, you're willing to listen to them, and also understands there are limits to what you can do. How do you build anything else in terms of building a relationship with your clients that you do, Nikki?
I think one thing is also important to remember, that if you say you're going to do something for your client, you have to do it. I think we talked about saying no. I think that it's great to say no. We should say no to things. But if you say yes, follow through, because the number one thing that will diminish some level of trust is not following through on things you say you're going to do. So I think that's really important to remember, keep in mind.
The last thing I want to talk about is costs. I know this was a question that was raised earlier. Both the Northern and Southern District on their website have procedures for seeking for reimbursement, or in some cases advancement of costs of representing a prisoner. It is limited roughly to $5,000. There are some ways to make exceptions to that in extraordinary cases, but you're going to have to really persuade a judge that this is an extraordinary case. These funds are limited, so it's not like they have a huge pot of money that they can hand out, and there are a lot of prisoners who file cases. In the Southern District, the majority of cases that are filed are, in fact, prisoner cases. That is also true in the Central District. The majority of cases that are filed are cases on behalf of prisoners. Not so true in the Northern District, but obviously there are very limited resources for this, but they do exist. They're on the court's websites as to how you can seek that reimbursement. So don't be afraid to ask for it. That's what the money is there for. I would also say that don't forget that if you win a case, you can petition for fees to be paid by the other side. Therefore, it's really important you keep detailed time records, which I know most of us do, but I know there's some personal injury lawyers who don't because they're paid as a percentage of their settlements. But nonetheless, in this situation, it's good to keep very detailed time records. And you can, if you win the case at trial, you can petition the court to award your fees. There are some limitations on the fees that you can charge under, again, the Prison Litigation Reform Act. caps attorney's fees for cases on behalf of prisoners. And again, remember, that's a question of whether or not they were sued. When they sued, they were a prisoner on the day they filed the complaint. It's roughly a cap on both hourly rates, which is currently at about $250 an hour, and also a cap on a percentage. That is, you can't get more than 150% of the damages that are awarded. Famously, I did a case on behalf of a prisoner at the Supermax prison who we claimed retaliation for. At the end of the day, there was no physical injury, and therefore all we got was nominal damages of $1, which meant our attorney's fees were capped at $1.50. Which, by the way, we had to put a lien on the warden's house in order to actually collect that $2.50. But as soon as we filed the lien, we got hand delivered $2.50 plus like 3 cents in interest. So there are caps on the fees, but again, if you get a significant verdict, then the attorney's fees can also be significant and can raise the value of the case significantly. We are taking a lunch break in about 5 minutes.
Just on that, Alan, I also want to note, like, keep in mind in the context of settlement, keep that in mind as a negotiation. Is, you know, when you win, you can get attorney's fees and they can be significant. So just keep that in mind as a leverage point with the defendants. You know, I often will run my hours and say, this is how much we put in the case already. You're on the hook for this if we win, when we win. So that's another kind of tool to use for settlement against the other side.
And then I would say generally, the other resource out there, there is a listserv of which is mostly people who are appointed, as well as, you know, half a dozen of us who do this for more or less full time. It's a great place to ask for things like, you know, has anybody taken a deposition of so and so? Has anybody, you know, got model interrogatories or a model brief on such and such that they can use? That kind of sharing happens all the time on that. The link for joining that is in the written materials at the very beginning under other resources. It's maintained by the firm of Kaplan and Grady. You do have to like swear under oath that you are not representing defendants, that you only represent prisoner side. So it is a listserv on which we share strategies as well as you know, documents and that kind of thing. The Uptown People's Law Center is also in the process of putting together a library of pleadings, etc., which will shortly, hopefully within the next month or so, be available to anybody who's on the listserv. So I think the only other thing to say is CLE credits will be awarded if you both registered and are on, and we have an attendance list of people who signed on to this seminar or webinar. Then we will submit your name to the Illinois MCLE board and can get CLE credit for that. If you're from another state, then I have no idea how they work. But if there are something that we can do to help you get out-of-state credit, let us know what that is. We know from Missouri lawyers, it's pretty simple. I know there's a form you fill out, and we provide you a copy of the timed agenda, and you can get CLE credit pretty easily. And it's been done over for these courses. I know that it does not qualify for Ohio's CLE credits. I have no idea about any other state. So if you think you're entitled to out-of-state CLE credit, just let me know about it. And with that, I think we will close, and we will be back to do the medical case, if you signed up for both of them, at 1 o'clock. If anybody has any questions, we can stick around for another 5 minutes to answer those questions. And I'll go through the thing here, but we are no longer going to present. Thank you for attending.